Applications Committee meeting of the 17th of August. Can I remind all members and all folks present to either put their mobile phones off or switch them to aeroplane mode? And can I like to remind everyone present that this meeting will be recorded and that the recording will be subsequently made available for public listening. Lucy, can you confirm Sederunt, please?
Good morning, everyone. We have 17 members present. We are quorate. And so far, I've got apologies from Councillor McComb and Councillor Hagman. Councillor Duty?
Ian Blake can't take part in the first item on the agenda, but he will be here after that.
Thank you.
Thank you. Noted, thanks.
Lucy?
And Councillor Fairbairn is not present, but maybe along later in the meeting.
Thank you, Lucy. Members, are there any declarations of interest? Jeff and Elaine.
Item 7, the sites within my ward, and I have met with the applicants and also attended public meetings, but I don't think that precludes me from taking part.
Thanks, Jeff. Elaine.
Advise that in a previous occupation I did meet with the applicants on this issue, but not this particular planning application. But I have had conversations about this issue. Equally, I don't think it precludes me from taking a decision.
Thanks, Elaine. John?
Yeah, item 4 on the agenda, I met up with the Burcote representatives, although I didn't make any decision on anything that was discussed.
Thanks, John. Hiver?
Chair, I think item 4, the last time I declared an interest that I'd met with the applicants, but didn't feel that I'd overstepped any mark, and item 7 would be the same. I've met with the applicants on that one, but haven't expressed any view.
Thanks, Ivan. A long time ago I met with the applicant as well on item 7, but it was just to understand what they were looking to do, and I don't think there's anything that will compromise my position. I've got Andy and then John Martin. Is it Joe McKee?
As my colleagues, I've met with the applicants for item 4, but I feel I'm able to participate.
Thanks, Andy. John?
It's item 4. I never noticed it the last one. I know one of the objectors, but it's a while since I've actually been in contact with them, but I don't think it precludes me from any decision.
Thanks, John. And Ronnie?
Yeah, I mean, I'll have to share a declaration of interest as well on item 4 due to the political situation at the elections, actually. So I would... And 5 as well, I mean, the Crossdykes situation as well. So I really do think I need to leave, actually.
That's fine, Ronnie. Thank you for that.
Okay.
Your decision, obviously, in all of these cases. If that's all the declarations of interest, can we then go to agenda item 4, which is the minute of the previous meeting, or agree any amendments that may be required? Happy to agree the minute, members? Thank you. Lucy, can you now outline the procedure to be followed today?
The Planning Applications Committee will consider each application in turn as detailed on the agenda. Case officer or other appointed officer will make a short presentation addressing the determining issues accompanied by digital images. Any late information, amendments or corrections will be reported at this time. Members may ask questions of officers following the presentation and points of clarification. The chairman has been provided with a list of eligible representatives who have registered to speak at this meeting within this period specified in council policy. No other persons will be allowed to speak. The chairman will individually invite those who have registered in advance to speak to make their presentation, after which they may be questioned by committee members. No questions may be asked of members. The order of eligible parties being heard will be as follows. Third parties objecting to an application. Third parties supporting an application. Statutory consultees objecting to an application. Elected members of Dumfries and Galloway Council who are not members of the Planning Applications Committee. Such members should withdraw from the committee chamber after making their presentation. Applicants or their agents. Representatives have been placed in alphabetical order, and a copy of the public speaking list is available from the committee officer taking notes of our proceedings. Presentations will be strictly limited to 3 minutes per person, excepting for national and major developments, which by their very nature are more complex, where the time limit will be 5 minutes. The chairman of the committee will ask you to come to a conclusion if you take too long. Representatives are encouraged to use the time allotted to clarify any points they consider material and address the determining issues. Certain matters are not normally planning considerations and will not be taken into account by the council when deciding on a planning application. Representatives should not raise any new matters without explaining why they were not raised earlier with the case officer. Please do not repeat what is in the report, as members will have already read the report. After all the representations have been heard, the meeting is then in formal session and no members of the public may address the committee from the public gallery. The Planning Applications Committee will then proceed to determine the application or, where appropriate, agree a recommendation to be made to full council who will determine the application.
Thanks very much, Lucy. We now come to the first item on the committee papers today, agenda item 4, which is a continuation of the previous committee meeting. Can you advise the committee, Lucy, which members can participate, please? I'm one that can't, so I'll have to vacate the chair.
Members who can participate in item 4, which is Longburn Wind Farm, 7.2 kilometres east of Carsphairn, Castle Douglas, is John Campbell, Jugie Campbell, Ian Crothers, Doug Fairbairn, Andy Ferguson, Andrew Giusti, Ivor Hislop, David James, Jeff Lever, Jane Maitland, John Martin, Jim McComb, David McKee, Elaine Murray, Ronnie Tate and John Young.
Thank you, Lucy. John.
Thank you, Chair. Okay, thank you, everyone. Item 4, which was the Longburn Wind Farm, 7.2 kilometres east of Carsphairn, Castle Douglas, planning application for erection of wind farm capacity of 23 megawatts, comprising of 10 wind turbines, maximum height of 134 to blade tip, site substation, meteorological mast, maximum height of 80 metres, temporary construction, compounds and formation of hardstanding, water course crossings, access to the B729 and associated infrastructure, planning application 16P20187. And Chris Mateer is not here, but we have Robert Duncan. Because we are in session, he will just go over a few items, just as a reminder to those who were participating at the last meeting. Robert.
Thank you, Chair. Just to follow on from that, as per the report at 1.1, there was a site visit which took place on Tuesday this week, that was the 15th, and that commenced at 10:30 in the morning. Now, there were various parties at that site visit, including myself, Andrew Robinson, Senior Planner on behalf of the Council. We had Jennifer Peltier from Invicta Public Affairs on behalf of the applicant, Stuart Winter of JLL on behalf of the applicant, Fraser Campbell of Burcote Wind, again the applicant, Mrs. Clubb, Fiona Clubb and James Clubb, who are objectors to this case, and also the following councillors: Councillor Dougie Campbell, Jeff Lever, Jane Maitland, David James, Andrew Giusti, John Young, Ivor Hislop, John Campbell, John Martin, Ian Crothers and David McKee. At the site visit we assembled at viewpoint 3 in the applicant's submission, that's at Guttery Glen in the B729. We then proceeded to the second viewpoint, viewpoint 2, at Stronefreg Craig Fort, which was slightly off the B729 to the north and involved some climbing as well. We then proceeded to viewpoint 4 in the applicant's submission, which was Smitton's Bridge, and we then finished up at viewpoint 5, Stronefreg Craig, which was a short distance south of the B729 on the Southern Upland Way. At that point, there was an opportunity for other parties to bring to members' attention any items they felt were important or members wished to observe. The members opted, at the objector's request, to visit Blackmark Farm to look out from there towards the wind farm site. Although there was no visualisation of the wind farm from that point, and Mr. and Mrs. Clubb were present when members did that. At Smitton's Bridge, the applicant and their representative wished to highlight the fact that all of the viewpoints members visited were quite local and close range to the application site, and there were obviously longer distance viewpoints as well which had not been visited, and those showed less visual impact. The other point I would suggest is that I've got the council's archaeologists present here today. There were some questions arising about the significance of various archaeological features during that site visit, and I felt that the council archaeologist as resident expert was best placed to answer those. So if any members have any questions about that, I'm pleased to say that Andrew Nicholson's here to answer them. The council landscape architect unfortunately isn't able to be here today because it's not a working day for her. She doesn't work on every second Thursday, so because of her working pattern she's unable to be present here today. I'm quite happy to go through the slide presentation that was shown at the last meeting if that's going to be helpful to members, Chair.
What do members think? Are we in agreement or not? Councillor.
Chairman, it would help me certainly. I've been to the site visit as well, but the more knowledge we've got in this one in particular, I think the better. Just it would refresh and keep everything certainly up to date for myself. Chairman, I would appreciate that.
Do we have to go through it all, or are you just wanting a particular part of the site visit?
It was just more the visuals, just to bring it back to mind. Which I don't. I'm not asking for loads of dialogue, but just the visuals in particular, because I've had a lot of discussion on it already.
Okay.
Quite happy to go through these quickly as best I can. Firstly, you've got the location plan showing the Longburn Wind Farm site in its wider context. So you can see Carsphairn. I'll try and get the pointer working. That's not that one. Sorry. Carsphairn's just to the left-hand side. You might be able to see it in the screen here. And you've got Money Ive on the right-hand side. Okay, thanks. And you've got the B729 public road just to the south of the application side as well, which is single track at this point with passing places. You also have, the other thing worth noting is the presence of the Southern Upland Way, which is the dotted line which comes up towards the site from the south and then traverses the application site. This is a much more detailed view of the site layout, and again as your reference point you'll notice the B729 to the south of the actual wind turbine layout itself. You're looking at a 10 wind turbine layout here, maximum height 134 metres to blade tip, and the site would include substation, one meteorological mast, temporary construction compound, hard standings, watercourse crossings, and an access onto the B729 as well. The turbine types, fairly generic. You're looking at 134 metres base to tip, as I've said, hub height coming in round about 80 metres or so. And that's your fairly generic substation compound with the building and then your palisade fencing that you would have with that. Turbine development within 10 kilometres. When members were out at the site visit, there were two that were visible in the distance. One, which was more close to the site, was at Weather Hill. So you see the green triangles is the development which has been built out at the moment. The orange stars or the amber stars indicate the present application that's there to extend that wind farm, but that has not been determined at this present time. You've got Longburn Wind Farm in the centre, as you'd expect. To the north, you've got the two clusters of Lord Wind Farm, which is an undetermined proposal at this point in time. You also have an undetermined proposal at Windy Rig, which hasn't come before this committee yet, but is due to do so. Then you have the cluster of interest here at Windy Standard 1 and 2. Benbrack Wind Farm, which is located there. South Kyle Wind Farm, which crosses the boundary with East Ayrshire, which has recently been granted following a PLI by Scottish ministers. Windy Standard 3, which is a proposal at the moment, Section 36 application. The council hasn't formally responded to that. And finally, you've got the Penclow application due to go to PLI at the end of September this year, and Afton Reservoir, which has been granted. So these are the ones within the area. To the south, I should mention, You've also got Blackcraig, which members will note has been built out. You've got Margree as well, and you have the application at Lochhill, which was recently refused following an appeal. So that sets the cumulative context within 10 kilometres. So for the avoidance of doubt, the other turbines that were visible at the site visit to the north were in relation to Windy Standard, and the ones to the east were relative to Weatherhill. And this is basically looking at the landscape character type with that additional overlay as well as the turbine pattern in that area. What you can see here is you can see Longburn in the middle in relation to the predominant southern uplands with forest landscape character 19A. And these are looking at the Dumfries and Galloway Wind Farm landscape character study assessments and landscape units. You've obviously got that adjacent unit very close by as well, and other ones as well. You've got foothills with forest and so on and so forth. And then as you come across, you've got the Southern Uplands Carsphairn unit LCT 19. These are all referenced in the actual report. This is showing the blue hatched areas, the blue and white hatched areas show regional scenic areas relative to the site. So members will note that the site itself is not located within a regional scenic area. Turning to photographs, this is looking towards the application site from the B729. So this is very close to the viewpoint that we looked at the site visit at Currie Glen. Very different weather conditions. We were quite lucky on Tuesday and we got fairly good visibility for it. And it was dry most of the time. This is a view looking up the narrow wooded river valley landscape character type. So that's LCT 14. And this is close by to Stonefreg and Craig Fort, the second viewpoint we went up to, which is topped by an archaeological feature. So that's looking towards the application site. You'll notice the watercourse on the left-hand side, which is the one that passes beneath Smitton's Bridge, but that's out of camera shot. Next one is from a similar viewpoint, so it's near the site of the previous photograph, but it's looking in the opposite direction. So you'll see the track there, which is forming part of the Southern Upland Way at that point. B79, it's not immediately obvious, is down about here at this point, and you'll also notice the cairn, which was visited as well during the site visits. So for the avoidance of doubt, this is looking towards the south, showing some of the landscape features, but this is looking away from the proposed turbines. The next view is looking towards the southwest, and it's towards Smitton's Bridge, which you can see there. You can see the dark arch over the watercourse, and the road takes a quite sharp left at that point. Another view to the south from that site as well, just showing the general landscape character and showing the course of the river. And then we move to the applicant's submission. So you've got a ZTV, a zone of theoretical visibility, which is a bare earth analysis, so worst case scenario of visual impact. It's showing the potential visible impact from turbine tip height. So the dark shaded areas on this plan show where, in theory, you would be able to view it from, view the proposed wind farm. So these areas, for example, the concentric rings indicate the distance from the centre of the application site. So what it's showing is that is reasonably contained, so what you are looking at are primarily issues arising within 20, 25 kilometres. That's 5 kilometres, 10, 15, 20. So the majority of the visual impact is quite close to the application site. This is a similar exercise, but the parameter looked at here is visual impact. So from which locations would you, in theory, be able to see each turbine's hub height when you look at it collectively? And again, you can see the dark shaded areas are fairly local to the application site. Cultural heritage assets within 1 kilometre. There's obviously, as you can see here, there's a lot of cultural heritage interest within this area. And again, all I would say, if members have any questions about cultural heritage within this area, there's a lot of reference in the report, but I'm glad to say I've got the council archaeologist on hand who's much better able to advise on these things than I am. Turning to the viewpoints, this is viewpoint 1, Stone-Fregan Bridge on the B729. So that is looking towards the application site. This is a photo montage. So gives members an indication of what you would look at if the development was built. Second viewpoint was one that was visited on Tuesday as part of the site visit, Stone-Fregan Craig Fort. So when you're up there looking beyond that small area of plantation, that would be what you would see. You've got the middle turbine, which, with avoidance of doubt, is just beyond that cluster of trees. Viewpoint 3, which is the first viewpoint that was visited on Tuesday. This is looking from Guttery Glen towards the application site. So as the B79 descends towards Carsphairn direction, you would look out towards the north, and that is what you would see as a visualization. Fourth viewpoint is Smitton's Bridge, which is the third viewpoint that was visited on Tuesday. As you look out, again, you've got that small area of forestry there. You'd see the turbines in the distance at the higher level, but again, at fairly close range. Viewpoint 5, Stone-Fregan Craig, again, quite local to the site. This is just to the south of the B79. As we found out, it's a wee bit boggy at that location, and it's slightly raised above the surrounding ground level, but it gives you a fairly close view of the application site, and again, that's very close to the southern upland way itself. These are now viewpoints that were not visited on Tuesday, so you're looking at longer distance viewpoints. Viewpoint 6, Garrick Hill, this is the map location, so this is to the east of the application site. So it's more elevated, so you're more looking down onto the actual site here. So you can see the surrounding landscape, Kinsmore, Carsphairn and so on, and other hills in the distance too. It shows also the significant areas of forestry plantation you have in this area. Next viewpoint, longer distance from Kilmark Hill. Again, this is quite elevated relative to the site. So maybe not quite looking down on it, but certainly at least level with the application site. And you're looking into the distance. From this viewpoint, it's fair to say you will get visibility. It maybe doesn't come out in this picture, but you start to then get visibility of the Windy Standard turbines on the horizon as well. B729 is, I think, down in this area. It's certainly at a lower point than is viewed here. Benbrack is off to the northeast, so when you're looking towards the application site, you're looking towards the southwest from Benbrack itself, and that's just showing the wider layout of the development. Viewpoint 11 is from the B7000, so B7000 is a road to the north of St John's Town of Dalry that eventually links into Carsphairn. Slightly longer distance view, so you're seeing it against backdrop of rising land there and forestry plantation as well. And that's a glimpse of the kind of view you would get if the development was built. Viewpoint 12, Dunduke Hill, not far from where the transmitter mast is. Again, this is quite elevated relative to the site, but that gives you an impression of how the proposed layout would look if it was built. Distant view, again, you've got that cloth of hills and elevated land there as well. This is from Ben Inner, I think it's pronounced, viewpoint 13. So this is off to the northwest, so looking back in a southeasterly direction towards the site. You'll notice it's very elevated, so this gives you a good overview of the site layout and how the turbines would relate to the wider topography. It's quite a long distance view you can get from here. So it shows how the site fits in relative to that, and it shows the topography of it. Next one's Craig of Knock Grey, which is pretty much due west of the application site. And looking across there, you'll notice the other turbines on the skyline there. Those are the turbines that have been built at Weather Hill. And then you've got a viewpoint from Alhang, which is to the north. And that's looking back, looking south towards the application site. And again, you're noticing the prevalence of forestry, monocultural plantation forestry here amongst the upland landscape. Mulwhani, similarly long distance view, and as you can see in the map, there's a lot of forestry plantation there as well, looking towards the application site. So that's looking broadly in a southwesterly direction. For Dennick Hill, looking mainly towards the east, you can see here again, you can see Weather Hill, you can see the application site that's coming over that crest, which is wooded. And Crossdykes to the east of the summit, much longer distance viewpoint, and that shows the cluster of turbines if the application was built and approved.
Thank you, Robert. Councillor Carruthers, are you quite happy with that? Are there any other councillors that wish to ask the officials whether it's archaeology or landscape? Councillor Ferguson.
Thanks. I've just looked at these viewpoint figures, and just for the record, I wasn't there because I'm not physically able to climb to some of the places. It wasn't because I didn't want to be there. 15 and 19, I think, were the only 2 to 21 slides where you can actually see other turbines. So I'm struggling to see where the cumulative impact is if you can only see 2 from all the viewpoints.
Robert.
The cumulative impact concern that's arising, as well as those that have been built, it's those that have permission, if you like, that haven't yet been built out, that have been taken into account in the analysis. So it's not just what necessarily has been built. You've also got to take into account what's been approved but hasn't yet been built too. That's really, you know, when you're looking at cumulative development, it's not, it goes beyond what's been built. You've got to consider other schemes as well.
Yeah, but we're looking at this application, not what might be coming in front of us at a later date. So how can they be realistically put into? No, some of them know. There's some they're saying are not being granted. That's what you just said just now.
Is that relevant to this planning at the moment?
Well, absolutely it is, because we shouldn't be taking something into account that might happen in the future. We should be looking at what's in front of us and what's actually in place and granted at this moment in time. I take the point, but this is the one that's come before us before the other ones. So I'm just trying to find out how on earth we're supposed to then make a proper judgment if we're working cumulative impact here on things that might come in front of this, or they've maybe declared an interest to bring, or they're at pre-planning stages or whatever. I'm kind of looking at David or on this occasion as to, is that relevant? Are we allowed to do that?
Thank you, Andy. David or Robert?
I think very quickly, the key part of the report, I think, which is of relevance here is, if you look at page 23 of the report, it's point I, and it looks at cumulative landscape. This is in the Council Landscape Architects Consultation Response, the summary of it. And it says cumulative landscape, influence of wind farm development on the eastern upper Glenkens. And it says Longburn Wind Farm in itself, and in addition to committed WED, so that's wind energy development. And then it mentions Windy Standard Cluster, so that's Windy Standard 1 and 2. Weather Hill Wind Farm and Black Craig Cluster would represent a tipping point with respect to the influence of wind farm development on the eastern upper Glenkens. So that's really, when there's a view being arrived at that cumulative development is unacceptable, that's, I think, one of the key parts from the landscape architect's perspective. That's certainly the way I was reading it. And the schemes mentioned, the Windy Standard 1 and 2, Windy Standard 2 is being built out. Windy Standard 1 was committed about 20 years ago. Weather Hill Wind Farm, as we saw in the slides, has been built out, and the Black Craig cluster is being built. It's not yet operational, but it's been built out too. So you're looking at more advanced schemes when that cumulative assessment's been undertaken and that view arrived at.
Thank you, Robert. Councillor James.
Thank you. I was just wondering if Robert could clarify for me. This proposed wind farm is not in a scenic area, but I wanted to know whether scenic area is one to which you look to or look from.
Robert?
When you're assessing it against LDP policy, I mean, the slide showed 2 regional scenic areas and the Longburn Wind Farm was in between. It's really assessing if there's going to be significant impact on the designated regional scenic areas. So you're looking at the impact from any proposal on the actual regional scenic area itself. So it doesn't need to be located within it, but if it's nearby, if it was, for example, 50 metres away from a regional scenic area, and it was seen to be impacting upon it, you could reasonably take that into account. But in this case, there's obviously a fair bit of distance in between the wind farm and the 2 regional scenic areas, such that I don't really think there's a case to say that there's really an impact there.
No, I wasn't questioning the impact. I just wanted to clarify for my own benefit whether scenic area is one that you stood in and looked to great scenery, or could look to from outside and expect to see something magnificent.
I would imagine that's a matter of perspective. So, Councillor Corrales.
Thanks, Chairman. Thank the committee for taking the site visit. It certainly helped me, and thank you for allowing us to see them slides again. Certainly an interesting one. For me, it's actually on balance. It's no just as strong a case in regards to how it's outlined within the actual papers itself, but the cumulative impact, that's where the site visit certainly helped for me. You can see what's there, you can see what's proposed, but like I think it's referred to earlier, we're looking at this in its own merits, I think, in this case, and we can certainly, some of the ones that have got a permission, we can take them into consideration, but when you're on site, looking at it as it is now, you get the understanding of the distances, how far away the other wind farms proposed and agreed actually are in context to this. The higher elevations, you see it kind of sits inside a hollow almost, even though it's very large.
Are you asking your question?
Yep,
for
I'm absolutely getting
clarification?
to that. I'm absolutely getting to that. I'm just putting the context in regards to the first piece, because there's numerous reasons why it's up for refusal. Like I say, putting it's kind of unbalanced. So in regards to the questions, and I asked this last time, and I'm glad the archaeologist is here in regards to this, I try to understand the difference between, because there's been clear, strong objections at a local level in regards to archaeology and landscape, but I suppose we've got the archaeologist here, but at a national level and international level, there's no objection. So just to, if you could put it into context, I've read this about 3 times now, just to try and fully understand it. I think I've got a fair grasp of it, but I think I need to understand why it's so significant from the council officials' perspective, why it's so significant at a local level when they actually in the national interest are saying, no, it's not really actually.
Robert?
I can cover the generality of the recommendation, that's fine. Each application, as it states at the start of the report section at 4.1, we've got to look, when we're making a recommendation to members, we've got to look primarily at the development plan. So at the moment that's the local development plan and the adopted supplementary guidance. It's a fairly fresh local development plan. It was adopted September 2014. Our supplementary guidance on wind energy development is very recent. That was something we updated the DGWLCS. We revised the supplementary guidance. It was adopted this summer. I think it was June time. Can't remember the exact date in June, but it was very recent, so we feel it's quite up to date. In assessing the application against the local development plan, we felt it contravened the policy in a number of areas. Now, that's not the end of the story, because you've then got to balance that against other material considerations and arrive at a recommendation. I accept the point, this doesn't raise any issues at a level that SNH or HAS consider compromise the national interest or international interest, but nevertheless, we feel in a number of areas that are listed within the recommendation it does contravene the LDP, and if it contravenes the LDP in a number of areas, there needs to be sufficient grounds, of considerable weight to justify departure from the LDP, and quite frankly, in this case, we don't think they really exist. But yeah, it is a balance. Every recommendation is a balanced view, and you're balancing fairly intangible things against each other, but it clearly is contrary to the LDP. We didn't really feel there was a compelling case here to depart from that. So on that basis, the recommendation's refusal. I'm quite happy to allow Andrew Nicholson to comment on the archaeological side and his view of the significance of that and how he's weighted that too.
I think the fundamental difference here is one of remit. Historic Environment Scotland have a very limited remit in which they can respond to planning applications. So they can only deal with the impact on designated sites, whether these are A-listed buildings, scheduled monuments, inventory design landscapes. This only accounts for approximately 5% of the historic environment across Scotland, and the other 95% of historic environment assets are purely dealt with through local authority, archaeology and planning services. So in the terms of this particular application, Historic Environment Scotland can only comment on the impact on Strown-Fregan Fort and Strown-Fregan Cairn, and discussions about the archaeologically sensitive area and all the other historic environment assets that you saw on there is out with their remit, and they are unable to comment on it. And that is my role, is to represent the broader historic environment and all the other assets that are within the proposed development.
Okay, thank you. Dougie Campbell.
Thank you, Chair. Having now read the archaeologist's report on 2 or 3 occasions and having visited the site, I think it'd be helpful if Andrew could summarise his reason for objecting, the significance that he considers the site to be in archaeological terms, and to just sort of summarise that in layman's terms, just briefly, please.
Andrew.
Certainly, one of the things that came out very clearly in Robert's illustrations is the large amount of forestry that covers most of the upland area. The area for the proposed wind farm has been designated by the local authority as an archaeologically sensitive area, particularly because it has not been ploughed for forestry development. And therefore, the fact that that is an area of open ground that has not been disturbed means that we have extensive prehistoric and medieval remains that would have covered all of that area, but we have lost significant elements elsewhere due to forestry. So a large area of the footprint of the proposed development is down in our policies as an archaeologically sensitive area because it has not been developed and because it has allowed, at times in the past when the climate was better, we had occupation higher up into the uplands. So we get this in the Bronze Age and prehistoric and medieval periods. And where there hasn't been subsequent intensive agriculture or forestry, we get this very well-preserved group of remains that show previous exploitations of the landscape. And the designation of archaeologically sensitive areas is to acknowledge where we've got these clusters of archaeological sites which are all interrelated to each other, which help us to understand the exploitation of our upland landscape in the past. And therefore, we have an archaeologically sensitive area within here, which not only has nationally significant sites, but have others that are regionally significant or more locally significant. So one of the principal reasons relating to my objection was a particularly well-preserved farmstead that's on the Southern Upland Way, promoted through their leaflets, and it's a very understandable set of remains. And its primary view shed is down into the valley that is looking over. And one of the turbines proposed is right on the edge of the direct area of archaeological impact and would sit in the key view shed that enables you to interpret the relationship of this site with its landscape. So it's elements like that that build up and create this cumulative effect where it falls against our policies for the historic environment and for archaeologically sensitive areas. And for the reasons I explained in my report, it got to there were sufficient times where it was contrary to policy that I felt that it took it over the threshold to warrant an objection.
Thank you very much.
Thank you, Andrew. Councillor Maitland.
Thank you, Chairman. Going back to the reason in paragraph 4.11, the things that we have to really take into consideration, one of the bullet points is effects on local amenity and communities. I'm curious, if I can ask the planner through you, Chairman, that despite the fact that we're to take into account the effects on local amenity and communities, when we went up to the site visit, on Tuesday, I was very struck that there was no visual from one of the objectors' properties, which is very close by. It's Black Mark. And I'm surprised not to have had that, because I think that was really quite an important viewpoint. And I wonder if there's any particular reason that you know why that was not added in by the applicants, because I think it should have been.
Thank you. Robert?
In very basic terms, we felt we had enough representative information showing the visual impact of the wind farm not to ask for that additional viewpoint. If we felt we were lacking in information or there was something we were uncertain about, we could have gone back and we could have asked the applicant for extra information, but we would have needed justification for that. In this case, we felt we had enough visual information to draw a conclusion on this case without asking for something additional. Obviously, the recommendation we've drawn is to refuse it. We wouldn't want normally to go back and ask someone for an extra visualisation if we were reminded to refuse it anyway, because they would justifiably feel that it was a bit of a redundant exercise, possibly.
Thank you very much, Chairman. Understood.
Thank you. If we have no more questions for clarifications, we'll go to recommendations. And the recommendation is to refuse. Oh, sorry. No. They have to debate. Sorry for the confusion. The recommendation is for refuse. Is there any counter recommendation? Ivor?
Chair, I went on this site visit, and to me, if you're looking to put a wind farm in a location, this one actually I felt was more sympathetic to the landscape than some that we have passed. One that I can go back to that I look back and think I got it wrong was Dulswinton, which sits right on the top of a hill, and you can see it from about everywhere you go round about it. And I actually think this one would actually blend in better with the landscape because it isn't as visible from out with the close proximity when you actually visit the site. So I would actually say that the impact that it would have on cumulative effect, because there was very few that could be seen from the actual area. I think it was 4 wind turbines that I saw looking from, was it the Guttery Glen site towards this wind farm. So I don't think the cumulative effect is there. And I actually think the way that it sits down in the land rather than up on the hills is actually an improvement. So I would actually be happy to approve this, subject to the usual conditions.
Do you have a seconder? I'll take Councillor Dusty.
I'll second.
I'll just let David in for a sec.
Can I just be clear, because obviously you've got to have the view is that this is contrary to the council's development plan, so there's got to be clear justification if you're going to be going against that. What would be the grounds for making an exception to policy in this case? Bearing in mind, Robert did show slides earlier that show that the cumulative visual impact, it's not just the 2 wind farms which are nearby. You've got to bear in mind the ones that have been granted in the vicinity, and indeed ones which are at an advanced stage, otherwise that they can come forward.
Chair, well, it says the proposal would have significant adverse cumulative. I don't actually think it would, because Black Craig, one that I have nightmares about because I had to sit in a planning inquiry, it couldn't be seen from this. So how can you have a cumulative effect if you can't see them? That's the problem. Cumulative to me is if you can see one here, one there, one there, one there, and one there. That's a cumulative effect. This, you saw the one, and you can't see very many from the site. So to have a significant cumulative effect, you must be able to see more than just the one wind farm or 4 turbines on another one. And I think there was 8 or 9 from Weather Hill. So I personally don't think the significant part comes into this. I think there may be a slight cumulative impact, but I think that's acceptable. And I think we need to actually consider, do we want the social, economic benefits to come out of this as well, rather than just the fact that, if it would on the top of the hill all the way around the tops, I would not support this because I don't like what we did at Dalswinton. I think it sticks out like a sore thumb. This one, I think, can be acceptable. And whether it's an exception to policy, I think that's one that's been used in the past. But I don't think the impacts after the site visit are as stark as what some of the other sites have been.
You want to respond?
Okay, so to a degree, the argument you're putting forward is that it's not it's not contrary to policy, in as far as that you're of the opinion that it's not going to have a cumulative visual impact because of the particular siting of it, and it's not going to have the adverse visual impact. Is that correct?
Chair, I think this one is, because it's a subjective objection that you've got, which is some people think it is, some people think it isn't, because you're looking at something. If it had been objective A, it can't be there because it's not in an area that we would consider as an area for search, then I would say there was you would have to have a clear reason to go against it. What we're saying is we think there is a significant impact. I don't think that is there. Now, I realise in the past that we can't just go with, I don't think there is one. However, I find it difficult on a subjective point to actually say, if someone looks at something and says, well, I agree with this, and someone else looks and says, I don't agree with it, I find it difficult to say that, other than there isn't a reason.
Okay, Ian.
Thanks, Chairman. I mean, I'm in the same view as Ivor when it comes to the cumulative effect, and I kind of outlined that earlier on. I don't buy into, from what I've seen on site, what I've seen on the slides, and what experience I've had within this committee and out with in the local area, certainly here, when it comes to the cumulative effect, I feel it sits kind of in a hollow, isn't naturally attached to any other wind farm in that location. But I mean, come back to the material reasons why, I think Ivor's right, and it's certainly what I'd picked up on. So you've still got the landscape and the archaeology to consider on top of the actual, but I mean, I think for me, material reasons why override that for me is contained in pages 49 and 50, I think it is, in regards to 4.8 to 4.85, and it's the socio-economic benefits, and that certainly plays a larger fact, and it comes back to it is important. There might even be a chance of discovery of another hoard. You never know. As part of the excavations, it would be quite major, but certainly that would be a long shot. But I think for me, Chairman, looking at having the experience of the site visit, put it into context, I think the visual impact wouldn't stop it for me. Potentially the landscape and archaeology, but actually the local socio-economic benefits in that area outweigh that for me, and I would support the motion to actually approve this rather than refuse it.
Okay, Councillor Maitland.
Well, at some stage, I'd like the elected members, if we're talking about socio-economic benefits, if that's going to go into the reasons for, we need to be absolutely clear about what they are, because I am utterly unpersuaded about them. As interestingly, is Carsphairn Community Council completely unpersuaded, and they are, should we say, wind farm kings up there. They like them on the whole, but they don't like this one.
Can I just stop you there? The community councils, although they were in the report, at the end of the day, they were disbanded, so they didn't become a legal entity. So their objections, which I understand being in the report, they shouldn't actually merit any sort of weight, you know.
That's quite all right, Chairman. I'll work through that myself, if that's all right. Going along and continuing on, the cumulative issues that we are talking about, I think much depends where you actually approach this wind farm from. When we drove up from Dalry, there was a wind farm, very visible, first of all, Weather Hill, and then you came round the corner and there was going to be the next one. So, and in fact, actually, over the top, Windy Standard was there too. So much depends on where you're coming from as to whether or not the cumulative effect was really very strong. I do understand that, but from where we drove up, yes, it was there, no question about it. Finally, the landscape and archaeology. I was really quite struck by the intensity of the numbers of archaeological artefacts that are there, and I think it's important, particularly for a place like Dumfries and Galloway, to preserve. Look at what we just discovered recently, further south in the Stewartry. I think it's incredibly important that we really do look after these things. Councillor Hislop mentioned Black Craig, and I'm not surprised he mentioned it, because one of the reasons that the council objected to Black Craig was the effect upon the Southern Upland Way. And bearing in mind the Southern Upland Way is going to be through the middle of this wind farm, there will be an effect upon the Southern Upland Way. So I'm surprised that we can't object to it on the basis of the effect on the Southern Upland Way. Clearly it didn't work last time round. I have absolutely no difficulty now. Earlier on, actually, I was prepared to dither over it, but I'm glad I went on the site visit. I understand only too clearly now all the richness of the heritage up there, and I also understand very clearly that there are people who are going to be deeply impacted by this, and whose opinions and whose visuals were not included in this. So I would caution members about going against this recommendation. I think that would be quite dangerous. So I propose to agree the recommendation, Chairman.
Thank you.
It was really just to go back to the point about socio-economic benefit, and there are a number of things listed on page 50, some of which I would have to say, with the benefit of hindsight, reading through, probably aren't. The paragraph 4.84 says they're generally considered. I think some of those probably aren't material planning considerations with the benefit of hindsight. But I would also draw members' attention to page 10 on your agenda and paragraph 4.14. That identifies that there be a requirement equivalent to 2 permanent full-time employees to operate and maintain the proposed development. So the socio-economic benefit on a permanent basis, other than during construction phase, is only 2 jobs. And is that considered, are members satisfied that's enough weight to argue that the socio-economic benefit of allowing this contrary to policy would justify it?
Councillor Ferguson.
Yeah, I take David's point entirely there, but what is the impact on rates for that if this was to be granted?
Rates is not a material planning consideration. We can't take that into account.
So it's not in the socio-economic, well, it might not be a planning consent matter. It's irrelevant. Is that what we're saying?
To the determination of the application, yes, it is irrelevant.
Councillor James.
On the point of the economy, I mean, the site visit for me was fantastic. I just saw what a wonderful area we've got up there and what potential we'd have to go tourism. And I think the last thing we would want to do is to put a wind turbine development and industrialised landscape in that area. And I see a cumulative effect because they're coming all over the place there. So I'm certainly against the project.
Are you seconding Councillor Maitland's motion?
Yes, with pleasure.
For refusal?
For refusal, yep.
Chair, it appears we have a motion amendment. I just really wanted for the minute to be absolutely certain what the grounds were for putting forward the approval. Certainly what I heard from Councillor Carruthers was the location was in a hollow and as such it therefore didn't have such an adverse landscape impact and had a reduced cumulative impact, and there was mention of socio-economic benefit. Is that the motion as it's going forward?
Yeah.
Well, Chair, I think that's where I was, they did sit in the lower land, that's what I did sort of suggest, so I'd be happy for that to be the reason.
Thank you, Ivor.
Have the motion put forward by Councillor Hislop and seconded by Councillor Giusti to approve the application on the basis that the site be...
Sorry, can I just be clear that it's approved subject to the usual planning obligations and conditions as appropriate?
Subject to conditions. And we have an amendment put forward by Councillor Maitland and seconded by Councillor James to views the application as per the report.
Thank you, Lucy.
Councillor Campbell. John Campbell.
Motion.
Councillor Doogie Campbell.
Amendment.
Councillor Crothers.
Motion.
Councillor Ferguson.
Motion.
Councillor Giusti.
Motion.
Councillor Hislop.
Motion.
Councillor James.
Amendment.
Councillor Lever.
Amendment.
Councillor Maitland.
Amendment.
Councillor Martin.
Amendment.
Councillor McKee.
Amendment.
Councillor Murray.
I was unable to attend the site visit due to a prior meeting on Tuesday, and I would wish to abstain in that case.
Just to state, you are still eligible to vote, but would you still like to abstain?
I do not feel sufficiently well informed,
Okay.
not having
That's
attended the
fine.
site visit.
Councillor Young.
Amendment.
And I can confirm that the amendment carries with 7 votes to 5, and therefore the application is refused.
Thank you, everyone. I would just like to say thank you to the members of public who came along just for this particular one. If you would like to leave, that's okay.
Thank you, members. We come to agenda item number 5. Erection of 15 wind turbines, 1 meteorological mast 80 metres high, control room and substation building, temporary concrete batching plant, formation of 2 borrow pits, 2 temporary construction compounds, crane standings, new access onto C80A, access tracks and associated works not in compliance with conditions 16, positions of wind turbines, tracks and crane pans, and 18 size and specification detail proposed wind turbines of planning permission reference 15/P/4/0142 at Crossdykes Farm, Lockerbie. This is a full application, reference number 17/0145/FUL. Recommendation approved subject to the successful completion of the appropriate legal agreements within 6 months of the date of the decision or any extended timescale as agreed by the appointed officer, and B, conditions. It's Annandale and Eskdale, and the case officer should have been Chris McTeer, but again, Robert Duncan's here to help us. So, Robert, if you could take us through your presentation, please.
Thank you, Chair. Just going through the slides, the first one shows the location of the application site itself. It's quite a large site, 397 hectares. It's 11 kilometres to the northwest of Langholm and 13 kilometres to the northeast of Lockerbie. Closest real place is Currie Common, and the wind farm is 4 kilometres to the northeast of that. The background to this case is given at 1.2 in the papers, so that's on page 61, which is planning application 15P4142, which was granted subject to conditions and a legal obligation by the Council on the 9th of September 2016. That was some time after it had been to committee for determination. this application that's made under section 42 of the Act. In terms of site layout, as you see here, there's no change proposed. It's a freestanding application in its own right, and what is proposed to change are conditions 18, which relates to micrositing. The present condition is at 1.6 in the report on page 62. The proposed version of the micrositing condition that's been put forward is at 1.8 on page 63. Cumulative plan, this does not, I should mention at this point in time, this does not include Hopshrig, which is a more recent submission which has come in for this. The other locus, if you like, of the application is in relation to condition 16. So whereas condition 16 of permission 15P4142 stipulated 130 metres as a maximum turbine height from base to tip, it's now proposed to go for a larger turbine type as shown, which is 149.9 metres base to tip. So in effect what they're proposing is an application that is the same in all respects, but with a greater micrositing variation and with a larger turbine type. So the submission is essentially a gap analysis between what has already been granted permission and what they are seeking by duplicating the original permission but varying the two conditions. So for the avoidance of doubt, this is a freestanding application in its own right. So the applicant always has the fallback position of the original permission which has been granted. So moving on, there was a comparative ZTV and heritage assessment undertaken, and this really was done to try and highlight, it doesn't really show well at all on this screen, but it was trying to show the additional visual impact from the larger turbine type which is now proposed. So it's the same number of turbines, same layout, larger turbine type base to tip. And the idea is obviously that would increase the electricity that would be generated from this proposal. So really the key component is trying to understand what difference that would make, if you like, to the visual impact and the impacts on archaeology as well as on landscape character and visual amenity. Similarly, this is a ZTV, it's much closer in range. It's of the Boykenburn archaeologically sensitive area, so very much focused on that because that was considered to be a key issue, and trying to look at what the additional impact was going to be. So the dark green area represents increased impact, if you like. So on a ZTV, this zone of theoretical visibility concept, if you looked at a bare earth analysis, you would in theory get additional visibility of the wind farm in those dark green areas. The lighter green, kind of olive green areas, you would already get visual impact from the approved scheme. So the difference is essentially marked in the dark green here. Visualizations and the photo montages possibly show it more clearly, and I'm hoping that these are quite legible. This is a viewpoint from Camp Hill Fort, and for the avoidance of doubt, the top photo montage image you're seeing is of planning permission 15P4142. So that's what's already been granted. The image below that is what is now proposed, or the effect of what is now proposed under this application. So that is showing the larger turbine type as a comparison. The next viewpoint, it isn't as clear here, but it's a similar approach. The top photo montage is showing the scheme which has been granted planning permission already from Craig Housestead's fort, and the bottom image is showing the photo montage of the proposed turbine type by virtue of the different condition. Again, similar idea here, the already approved scheme at the top, the proposed wind turbine type at the bottom, and this is from Newland Hill Fort, again, of archaeological significance. And finally, skipped on a bit, this is a wireline diagram, it's from Boykenburn itself, and the top wireline diagram is showing the existing proposal. Now, for the avoidance of doubt, it's the one in the centre in the blue, which has the turbine numbers on it. The bottom one is, in effect, what is now proposed with the larger turbine type. The one on the left-hand side is Logan Head, which is a separate wind farm. This is a ZTV2 blade tip with viewpoints shown. The viewpoints are the blue dots you can see clustered around the centre of the diagram, and if members can make out the black dots, those are the actual proposed turbines themselves. As I've mentioned, the layout of the development is not changing in comparison with the previously approved project. Moving to other photo montages, this is viewpoint 2, which is from Bailey Hill. This is in relation to the larger turbine type. So you've got an idea of how that would look. Viewpoint 3 from Black Esk Bridge. Viewpoint 4, Whit Castles and Crossdykes Core Path. You can see the proposed turbines there on the left-hand side. Moving to Castleower, Forest Hill Fort, you can see the proposed development and the revised turbine type in the middle of this visualisation. And finally, a viewpoint from Currie Common, and you can see the development in the distance with the larger turbine type on the left-hand side. Probably in terms of looking at the two issues, landscape and visual impacts, members will notice we have objections in consultation from the Council's archaeologist and the Council landscape architect in relation to this case. Again, like the previous case, you've got to determine these in accordance with the development plan, prevailing development plan and other material considerations. So we've tried to weigh this up very carefully. If I could guide members in terms of the landscape and visual impacts, if I could guide members in terms of our overall thinking and conclusions, I would draw your attention to paragraphs 4.30 and 4.32. So those are on pages 84 and 85. So in summary, obviously if you increase the turbine tip height and you increase the micrositing allowance, there's the potential there to increase significant landscape and visual effects. That's recognised. But notwithstanding that, in the comments we've received in consultation, we also recognise the policy context of this development, and in policy terms, the wind farm, as proposed, is located within an area of greatest potential for large wind turbines. So those are turbines from 120 metres to 150 metres base to tip. And that's identified within the Council's interim spatial framework, which is within policy IN2 of the LDP. So looking at it on balance, we feel the siting and design of the proposed wind farm as it's amended now is still generally considered to be consistent with the guidance contained within the DGWLCS. But we do acknowledge that that is at odds with the landscape architect. When we look at some of these visualisations, we're finding it difficult to discern a real difference between the two proposals and therefore the impacts arising from the development. It's a fairly subtle difference of around 20 metres. But crucially, it keeps the proposed turbines within the large turbine typology, so it isn't increasing 150 metres. Now that's clearly an unbalanced view. We've weighed things up, but we don't feel that the proposal on balance offends the LDP policy. We feel it accords with it. Turning to micrositing, I should maybe say that the cultural heritage impacts, again, similarly to our views drawn in landscape, we're struggling to see a real difference, as you saw in the visualisations there, between what you would observe from the key archaeological sites as well as officers, certainly, notwithstanding the comments of the archaeologist. With micrositing, which is the other element of the proposal, in comparison with the background one that has already been granted permission, paragraphs 4.14 and 4.15 really cover that. We would consult widely if micrositing was to be greater than 50 metres, so between 50 and 100 metres, we would consult quite carefully on that. When it's less than 50 metres, the project's environmental clerk of works would require to give authorisation to it, so there would be some input there, but we feel that we can control, if you like, the worst aspects of micrositing if they were proposed when it's between 50 and 100 metres. we've seen similar conditions to what is proposed there in appeal decisions recently. So in conclusion, we're reasonably relaxed about the suggested condition 16. And in conclusion, we feel that the development does accord with Council's LDP and therefore have recommended it for approval, subject to the legal agreement and the conditions listed in the report. But happy to answer any questions arising, Chair.
Thank you, Robert. Any questions for the case officer? Archie and Elaine, and then Jock McKee.
Thank you very much, Chair. As I see, there's a little bit of difference between the last one and this one, in that, you know, they've thrown out the council landscape architect for this one because there's a different recommendation coming forward. I think the issue for me was looking back at those archaeological effects. There was a similar amount from the previous one. I was watching it next door. Can you just tell me why the landscape architect isn't here to ask any questions for members?
I would think because it's already approved, but Robert?
The landscape architect's not here because it's a non-working day for her. She works a flexible working pattern, and she doesn't work for a council every second Thursday, and today's one of the every second Thursdays, so she's not at work today.
That's it. I suppose that's a good enough answer, actually. Elaine and then David McKee.
Yeah, thank you. I wanted a little bit more clarification about the micrositing, because Historic Environment Scotland was concerned about the impact on 2 scheduled monuments, and they wanted to be included as consultees in condition 16, but they haven't actually, that requirement hasn't been placed in condition 16, and I wondered whether there was a reason that you didn't specifically want to accept their suggestion that they are consultees in respect of the micrositing.
I've got David for that, Elaine.
Chair, if I could just refer members to page 91 of your agenda, the recommended condition 16 there does require, and it's, I think, the 4th line down, and Planning Authority in consultation with Historic Environment Scotland has given written approval for any such variation micrositing. So yes, it is included on page 91.
Sorry, that seems to be it doesn't seem to be included in the one at the beginning of the paper.
Yeah,
there's a slight
but
difference between both bits of the paper. But that's fine. If you can,
it has been dealt with.
Well, they will be consulted.
Yeah.
Okay.
Thanks, Elaine. I've got Jock McKee and then Andy Ferguson.
I seem to be complaining about the same thing. It's this increase in sighting from 50 metres either way to 100 metres either way. Virtually the photographs and montages and all that we've been shown could be totally irrelevant. The turbines, if you can be moved 100 metres either way, goodness knows what sort of sighting we'd have there. So should we not have something more accurate than that? I kind of wonder just what exactly the company's up to want a variation like that, if 50 metres is not enough.
I appreciate the point you're making, but there is a condition that we must agree to any alterations, however minor they might be. But Robert, do you want to just respond to Councillor McKee?
I'm quite happy. The rationale behind it very much is summed up at paragraph 1.7. So this has come from the applicant. They're saying the practicalities of developing the site, including the isolated pockets of peat identified within the previous application's ES, require a more flexible approach to micrositing than previously considered in order to position the turbines and infrastructure in such a manner as to have least impact on the site locale. There are always, when building these things out, issues that arise at the construction phase, and sometimes they've got to make decisions to move things. On the face of it, 100 metres sounds like quite a lot, but generally the visualisations will end up very similar. What we're saying is up to 50 metres, they can microsite up to that, and that's a fairly standard requirement. What's not standard is 50 to 100 metres, but that would be done in writing with the Council's Planning Authority in consultation with Historic Environment Scotland. I think the difficulty here is you've got 3 versions of Condition 16. You've got Condition 16 on the original planning permission, which is a separate thing. You've got in the background the Condition 16 the applicant would like, and then in the recommendation you've got the Condition 16 which we are recommending, which is different because that does require it to be in consultation with Historic Environment Scotland. But you can, to answer the question, you can end up with a different scheme by virtue of micrositing, but it shouldn't really be significantly different. And that's something we take into account when we consider, any written request for a variation between 50 and 100 metres, we would think at that stage, is this really going to result in any additional visual impact, particularly to residential properties or key receptors? So it's something we try and avoid, and there would need to be obviously good reason for a change to the position of the turbine that would need to be demonstrated to us as well.
I suppose an interesting by question to that is, if we approve this today and that's not a decision we make, are we then given delegated authority to agree on changes, or if there's a significant change to the visualisation, or there would be if it was approved, would that come back to committee as an alternative proposal again?
It would effectively be saying, Chair, that the Clerk of Works, Ecological Clerk of Works, would have the ability to accept the micrositing of up to 50 metres, but then the Councillor's Planning Authority, which it would normally be a delegated matter, would be looked at in consultation with Historic Environment Scotland. If they were wanting to come back with anything which exceeded 100 metres, or they wished to further amend the terms of the proposed Condition 16, you're talking about a whole new planning application.
So we are delegating authority if we get to that stage. Andy?
To be fair to the landscape architect and the historical one, they're being consistent, and I'm also picking up here, for example, it's got Scottish National Heritage on page 74, no objections, but on page 75 they're actually telling you why they're not happy. So how can there be no objections, I suppose? And that's a throwaway comment, but the question really is, there's a number of objections here. So what actually is the rationale behind the recommendation to approve? Because it's going against our own architect, it's going against our own historic folk, it's going against the local community, but it seems to be up for approval. And I'm just trying to find out no casting any aspersions at all, didn't take me the wrong way. I'm just trying to get the mindset of how we can actually reach that conclusion reasonably.
I think Robert can set that. Remember, this is an approval. This is simply an alteration or a minor amendment to an approval. We can't stop and we can't change. But Robert, can you address Andy's question as best you can, please?
Yes, absolutely. Earlier I made reference to paragraphs 4.30 and 4.32, which relate to landscape and visual impact primarily. And in this case, yes, as I've said, we do have objections from consultees. The Council's landscape architect has objected, the Council's archaeologist has objected too, primarily on the basis they have concerns about micrositing, which I'm less concerned about. I don't really think that's a significant issue if we phrase the condition in the right way. For me, the determining issue is whether the increased turbine size is acceptable or not. Does it meet with our policy or not? If it doesn't meet with our policy, are there reasons to support the application? Fundamentally, for me, the key thing is looking at the policies. They're generally supportive of large-scale turbines, and although the previous ones were smaller, these are still a large typology turbine type. Additionally, while the impact of these is logically, because they're bigger, greater, I don't feel it's crossed a line into unacceptability. But I realise that that is contrary to the view of our landscape architect, but I don't feel that our policy is being contravened. I don't feel the LDP is being contravened. Ultimately, it's a judgment call. I mean, the planning decision's an absolute. You either grant it permission or you refuse it. You don't give it a mark out of 100. But has it crossed that line of acceptability or not? Is it contrary to the LDP? The case officer and myself agree that we feel this is compliant with the LDP and it should be supported on the basis it's still large-scale turbine development, and we're struggling to see any real discernible difference between the visualisations from key viewpoints.
Andy, aye.
Thanks very much. I think the last bit, I appreciate this industry is a bit like the mobile phone industry, well, smartphones nowadays. Right, what it was brand new yesterday, tomorrow's history. There are a lot of developments. So basically what you're saying here is that this becomes more efficient doing it this way and produces more electricity, and that's the thrust of the thing.
Robert?
we're being told by the applicant that the larger turbine type would generate more electricity than the previous permission, yes.
Thanks, Andy. Any other questions by members for officers? John and then Elaine.
Thank you, Chair. I just wondered, and perhaps we can't ask this, is the increase in the size of the blade necessary to make the project viable in its original size? Is it borderline?
The applicant will be speaking to the committee, John, and there'll be an opportunity for you to pose that question to him. I'm sorry I missed Patsy earlier. I've got Elaine and then I'll get Patsy.
It was just in terms of the objections from the council archaeologist and landscape architect. Did they object to the original planning application?
Do you know, Robert, given that it was Chris McTeer that was the planning officer that dealt with this?
I'm fairly sure they did not object to the original application.
So there is something about the increase in the turbine height and the micrositing which has changed their mind about this application?
It would appear so.
If you like, the way I would term it would be that they're essentially looking at what is different about this application compared with the previous one, so it's based on the gap analysis. So the question therefore is what is proposed now unacceptable in comparison with what's already got permission? So in their view, from that, their view is obviously this is a step too far and they view it as unacceptable.
Thanks, Robert. Patsy?
Thank you, Chairman. I'm looking at the heads of terms legal agreements, Robert, and it's on page 87. And I find in all three of them that they're kind of lightweight. And I was just wondering, we used to talk, if you take the first one, it's an acceptable financial guarantee. We used to put in something called a bond, which felt there was a bit of commitment about it. An acceptable financial guarantee sounds a bit wishy-washy to me. And then you go on to the second one, an obligation to correct interference. I don't know who the obligation is with because it doesn't say. And nor does it say who the financial, guarantee in number one will be either. And I just think there should be something stronger there, that it will be corrected. It's not an obligation. It's something that I just feel obligation doesn't give the strength that we would require for these things to be implemented. And, the devil's in the detail. Well, it always comes back to us and we say, oh, well, that wasn't the intention, or we didn't do it strong enough. And I think with the third one, an obligation for the developer to repair and damage the roads. I wonder how we're going to insist that they do this, and if we actually can with just an obligation as opposed to something that is stronger. And what happens if it's not the same person who is constructing the thing as who decommissions? Is the same obligation carried over with different companies? I just feel we have an opportunity to have a slightly stronger heads of terms here, and this is the time to do it. I feel this is weak.
Thanks, Patsy. I think as far as deconstruction, we have a bond that covers that, but David will maybe explain things for you.
Thank you, Chair. Yes, I mean, these are simplistic heads of terms to explain what the purpose is, but it is not the full-blown legal agreement you're saying before you, which we would use a Section 75 planning obligation under the Planning Act to cover financial guarantee. There are other methods in bonds, but bond is the most common way. We allow the applicant to come forward with any other suitable alternative measure, but you're right, a bond is what we would be really seeking there. Things like television, it is an obligation. It's less likely to crop up now that everybody is on digital television. It was more a problem when people had analogue television, but it is nonetheless something we carry forward, and it's normally Section 69 of the Local Government Act that we use to bind the developer into sorting out the roads after any construction traffic. What we normally require, and again, the detail is not put before you, this is just heads of terms, but what was normally required is a video footage of the pre-commencement state of the road, so it's quite clear what has been done by the developer and what was existing, and then they're required to sort that out pro rata. So yes, there's a lot more behind this. There's legal parties from both sides get involved, and there's a great long legal agreement is drawn up. This is really to give you a flavour of the key issues that we're wanting to be targeted.
Dent with that, Patsy?
Just,
Yeah.
I don't really quite see why we have it if it's not actually what's going to happen. I mean, okay, I'm glad you have stronger heads of terms, but what's in the report here, which is what we're dealing with, does seem to me to be rather weak.
I think it happens often that we wouldn't want a huge volume in every paper simply outlining what the legal requirement was, and just lets members know that that's actually going to happen. Hey, Dougie?
Thank you, Chair. Just to return to the archaeologist report, just seeking a wee bit of clarification here. Paragraph 2.6, about two-thirds of the way down, it states, as noted in the previous responses, it is considered that the assessment of these sites and the impact on the proposals on them has been underestimated. Is this the current archaeologist criticising previous archaeology reports, or can you just clarify what's actually being said there? Because having read it several times, I can't get the gist of it. Thanks.
Robert?
Sorry, Chair, I'm trying to find the part of the... I think... It says, is it the part where it says the previous responses suggested that the turbine layout approved in 2016 was demonstrably adverse, but that it fell very slightly below the level that would merit an objection?
I'm on page 65, Robert. Apologies, I should have given you that.
That's fine. So at point B, where it's saying where it's being, but it says impacts of the proposals on them had been underestimated in the view of the landscape architect. That is in relation to the applicant's submission. So it's, when it says submitted report, notes from the key findings from the ES and addendum, and the section on cultural heritage, that's basically the council's archaeologists commenting on the applicant's submission in their ES and supporting information in connection with this application. So they're basically disagreeing with something that the applicant has submitted.
Thanks for that. Thank you.
Cheers, Dougie. Members, no other questions? In that case, we come to the first speaker of the day. It's Mr. Alistair Yule, the applicant. This is a full application, Mr. Yule, so you'll have up to 5 minutes to speak to the committee. I will remind you with 30 seconds to go, just to draw your presentation to a conclusion if you approach the 5-minute time. And just whenever you're ready, thank you.
Yeah, understand. Okay, first of all, I'd just like to thank members for allowing me to address the Planning Committee today with regards to our Section 42 application for our consented Crossdykes Wind Farm. My name is Alistair Yule and I'm Senior Development Manager at Muirhall Energy. Muirhall Energy is an independent renewable energy developer based in rural South Lanarkshire, focusing on wind development both small and large scale, with a portfolio of projects throughout Scotland. Our office is located next to our own 11-turbine operational Muirhall Wind Farm. I'd like to start with providing some background as to why we have requested to increase the overall tip height for the project. When the project was first envisaged, onshore wind in the UK received government support through the renewables obligation. This meant that generators would receive a top-up to the wholesale electricity price generated for the project, which was guaranteed for 20 years. To put this in perspective, generators qualifying for the RO typically received £90 to £100 per megawatt hour. The industry was well aware that the RO was to be closed to new entrants from the 31st of March this year, being replaced by a sealed bid auction called Contracts for Difference. The intention of this was to drive down costs through competition between generators and ultimately reduce costs to the consumer. Members may be aware that the UK government announced in June 2015 that it planned to remove all new subsidy for onshore wind, and it has been confirmed that support will also not be available under Contracts for Difference. This now means that sites such as Crossdykes will require to be viable on the wholesale price alone, known as subsidy-free, at a cost of roughly half of a rock project at circa £45 to £50 a megawatt hour. It is important to note that all forms of generation require some form of subsidy to be viable. For example, the planned Hinkley C nuclear power project last year received a CFD for £92 per megawatt hour for 30 years. New build gas needs £52 a megawatt hour. We believe that we can deliver a subsidy-free project at Crossdykes cheaper than any other form of generation. In order to do so, we will need to reduce both capital and operational spend across the board, including costs for turbine supply, grid connection, landowner and civils costs. Critically, we will also need to ensure that next generation turbines can be installed in the site to increase production, which is why we are requesting a tip height increase. I would now like to touch on why we ask the members of this committee to follow the case officer's recommendation to approve this application. You often hear comments with regards to wind farms being fine as long as they are located in the right place. Our Crossdykes proposal has demonstrated that it very much is located in the right place due to the following. Members of this planning committee unanimously saw fit to consent the site last year, and I would just like to reiterate why this was the case. Firstly, the site is identified in Dumfries and Galloway's LDP as being wholly within an area of greatest potential for large-scale turbines. The site is out with any statutory or non-statutory environmental designations and in an area which is sparsely populated, the closest village being some 4 kilometres distant to the west. We have a significant local support, including from the host community council and the 2 other closest community councils, as well as other many local businesses. Analysis has shown that increasing the tip height only increases visibility by 3.8% to the surrounding area. For a modest increase in tip height, we will be able to provide cleanly sourced power to an additional 7,600 homes per annum, taking the total to 39,785 homes a year. As well as an annual £240,000 community fund, a 10% community ownership offering has been made to the local communities surrounding the wind farm, which means it has the potential to be the largest community shared ownership project in the UK, as detailed by a recent Friends of the Earth report, which I have here if any members are interested. We have also committed to a local skills fund worth £250,000 for the first 5 years of operation. Ensuring jet electricity is generated at the lowest possible cost to consumer is the right thing to do, and the Scottish Government in its draft energy strategy published at the start of this year has set a challenge to the industry that it wants to see the UK's first commercial wind farm without subsidy developed in Scotland. We are ready to take up this challenge and deliver on promises we have made to local community groups and businesses. We therefore respectfully ask that members follow the planner's recommendation and approve this application today. Thank you.
Thanks very much, Alice. If you'd like to wait a minute, I have 1 or 2 questions for you. John did pose a question earlier, so I'll have you first, John, then I've got Archie, Elaine, so far.
Well, Alistair, thank you for that presentation. I was just wondering if this change was necessitated regarding the viability of the whole project.
Yes.
And if the change didn't happen, would the project not happen?
That's correct, yes. We've rerun the economic model, and based on the complete removal of support for onshore wind, it now makes the project non-viable at the 130 metres to tip. When we first envisaged the project, we all knew that the renewables obligation was going to be phased out of March this year, and we were preparing this project to be what's called the Contracts for Difference project. To me, that makes perfect sense. It meant that there wasn't a carte blanche subsidy given to developers. It meant that only the most economically viable sites, the windiest sites, the least build cost sites would be developed. And there was a finite pot of money that the government had set aside for doing that. So us as a company, many other companies had developed sites on that basis. And we were very disappointed that obviously there's no support whatsoever now being given to onshore wind. So we will have to compete wholly on the wholesale electricity price, which is sort of circa 45 to 50 pounds a megawatt hour. So we've pretty much halved the revenue that you would have received on a ROC project. So there were some projects just being built out at the start of this year that qualified for the ROC and grace periods. But projects such as Crossdykes, which wouldn't be able to be built out in time for that, do not qualify for that subsidy. And anything going forward from this point, there's no subsidy available for sites. Therefore, we need to go back to the drawing board, not in terms of design, but in terms of looking at turbine costs, landowner costs. Everything has to be stripped back to make these projects viable. But as I mentioned in my presentation, critically, you know, a wind farm, the whole purpose of a wind farm is to harness power from the wind. And there's next generation technology on the market at the moment, up to 149 metres to tip, which we feel will make this project viable, and we can build out, you know, the project. We have a grid connection of October 2018. We'll probably have to push that back to 19 just because of delaying things. But if we get this tip height increase today, we'll look to start building probably next year or into early 2019 for Crossdykes. And it may well be one of the...
Sorry. Just extending beyond the yes or no.
Right, okay.
Archie?
Like most people do, something to do with wind. Alice, thanks very much for giving your presentation. You did say that you had contacted the community councils within the ward, and there are no representations here objecting to that from community councils. Can you tell us what sort of communication you did with those community councils for the upgrade that you are now seeking?
Well, we had various discussions with some of the members of the community council to say that we're going ahead with the tip height increase, and we also advertised it in the the local papers as well. I think there were a number of articles that came out in the paper as well. So that was the crux of it.
Elaine?
Yes, I can fully understand that the problems with the removal of the rock would give you company with it in terms of the timing of your project. My understanding is that some companies are addressing some of that problem by improved mechanisms in the generation. I think improved gearing mechanisms, which makes actually the generator more powerful and the wind turbines themselves more efficient. And I wondered whether that was considered. Is that not a possibility in terms of that you are having to go to a greater turbine height rather than improved efficiency?
Well, we have a couple of sort of candidate turbines in mind for this particular project, and going up to the sort of 130 metre swept rotary, they are the sort of next generation turbines. Turbines of that size are pretty common on the continent, but in the UK we seem to have been kind of stuck at sort of 125 to 130 metre mark. But as I say, on the continent, turbines can quite often be up to sort of 200 metres to tip. The turbines that we have in mind are next generation turbines, and we believe will deliver the most yield per turbine and across the site as a whole.
Thank you. Andy?
It's partially been asked and answered. A question it was about the turbines. I was going to ask you the question about, and I'm assuming the new technology is just developing day by day, as kind of said earlier.
It is, yeah. I mean, since we got consent last year, there's been many different turbine manufacturers coming out with next generation technology. We're now looking at sort of 3.8 megawatt generators, 4 megawatt generators, whereas typically it's been sort of your 2.5 megawatts. But that's certainly where things are moving. In a subsidy-free environment, anyway, that's the way that they'll have to move.
So can I come back, Jim? So the sort of yes or no is this is to improve efficiency.
Yes, of course. Yeah. That's the number one.
Thank you.
Yeah.
If there are no other questions for the applicant, if you'd like to take your seat again, Alistair, that'd be fine. Thank you very much. Members are now in session. Archie?
Thank you very much, Chair. I can remember doing this one last year, and the report is fine as far as I'm concerned. There is one, however, one thing I'd like changed in the recommendation, and it's at page 87. Can we have a legal agreement rather than a legal arraignment? Because I don't know what an arraignment is, and go with the recommendations in the report. 5A, legal arraignment, heads of terms. It should be a legal agreement.
Where's that?
Page 87, 5A. Under 5.1, legal arraignment rather than legal agreement.
I take it you're telling us it's a spelling mistake.
Yes.
That's fine. Okay.
There might be another thing.
I'm sure
an arraignment is. I don't know.
So you've proposed we go with the recommendation. Yeah. Are there any alternative views? In that case, Lucy, just confirm the decision of the committee, please.
And the committee have decided to go with the recommendation to approve, subject to A, the successful completion of the appropriate legal agreements within 6 months of the date of the decision or any extended timescale as agreed by the appointed officer, and B, conditions.
Thank you, Lucy. Go to agenda item number 6, alterations and extensions to hotel at Port Logan Inn, Port Logan. The application type is full planning permission. The reference number is 14/B/1/0495. The recommendation is approved subject to conditions. It's Wigton West, and the case officer is Billy Murray. Billy, when you're ready, will you just take us through your presentation, please?
Yes, thank you, Chair. This is an application for alterations and extension to a hotel formerly known as the Port Logan Inn Hotel in Port Logan, now known as the Port Logan Bay Hotel. Members will note, and some members will indeed probably recall, that this property has considerable history going back to 2011. So I'll perhaps, in my introduction, just briefly summarise that history, albeit that it is in the report. In 2011, a proposal for alterations and extension to the hotel was approved. You'll see that under paragraph 1.6 on page 98. That's 11P10334. So there was an approval for alterations and extension to the hotel at that time. Work subsequently commenced. It subsequently came to light that the works were not proceeding in accordance with the approved details under that application. Following challenge and enforcement action and 2 false starts in 2012 when applications were made seeking to regularise changes to the approved development, an application was ultimately submitted in 2013 under 13P10175. That application sought to regularise the previous changes, but also included an even larger extension at the rear and significant alterations to the front, even beyond what had been approved in 2011. Planning Applications Committee refused that application. That refusal was appealed, and the Scottish Government reporter similarly dismissed that appeal and refused to grant planning permission. So where we stand at the moment is that works have ceased in accordance with the stop notice and enforcement notice, which are still in place. The stop notice required the cessation of any works other than those approved under the 2011 approval, and the enforcement notice effectively required reversion to that approval. In other words, removal of any unauthorised elements and reversion to the details of the 2011 proposed development. After a long hiatus when various iterations of what's now proposed were put forward, we got the application in 2014, which is now before you. There have been many amendments to that over the past number of years, and particular concern has arisen regarding flooding on the site, which was not considered in detail under the 2011 and 2013 applications. It has to be made clear at this stage, however, that the site is not within a flood risk area. The question of flooding has come to light because of representations from third parties and evidence provided by them in terms of a previous flooding event, and the fact that as part of the unauthorised works, the previous open water channel that traversed the site was built over and put in an underground pipe or culvert. So those two things in combination, the representations on the grounds of flooding and the unauthorised works in the culverting of the previous open water course, led us to consult SEPA on flooding and our own flood risk management team, both of whom initially objected. So there has been, as I say, a long hiatus while various alternative proposals have been put forward and considered by SEPA and flood risk management team in terms of their remit to control flooding. So that's briefly the background to where we are now. I'll take you through the slides. So So that's the location plan at the northeastern end of Port Logan Village. The site comprises the hotel property itself, which is on the southern side of the road, and a car parking area on the northern side of the road. So it's a two-part site, as you'll see there. That's a closer view of the application site. The former Port Logan Inn and to the south of the road, and the car park to the north. This is the front elevation as it is today. Elements of unauthorised work have been started on the front. You can see the blockwork wall on the right-hand side there, and part-built wall along the front. That was the forward extension, known as the tea room extension in the application. As I go through, I'll show slides as it was previously, and you'll see from the drawings the changes as a comparison to what it is now and was previously. So that's as it is now in 2017. That's from the northeast. That's from the northeast, showing the northeastern gable elevation and the front elevation. This is from the southwest. Sorry. This is the access to the rear from the road. On the right, there is also a part-built extension. That would remain. This is the rear elevation as it is today, again with part-built extension to the rear. Another picture from the rear. And this is the rear service yard as it is today. Another of the rear service yard as it is today. This is what would be the tea room, so this is the forward extension. And this would be the side extension. This was the front elevation in 2013. Particular points to note here are the sandstone pillars, which were proposed as part of the 2013 application, but were rejected as part of that refusal. These have now been removed, as you'll have noted from the earlier pictures. So at least that part has been removed, and they are no longer proposed as part of the current application that's before you. Again, that's a similar view to previously from the northeast, as it was in 2013. As it was in 2013, there's no change in that view from then until today, other than the removal of the sandstone pillars. Down the side, as it was in 2013, the only difference there is the construction of a wall and fence on the left, which is by the adjoining proprietor. It's got nothing to do with the current application. That's the rear elevation in 2013. Again, the rear elevation in 2013. It's perhaps worth saying at this point that as proposed under the 2013 applications and indeed the 2011 approval, there would be a much larger extension coming right back to cover almost where I'm standing in that view, and would have filled almost the whole of the rear of the site. So that's a closer view of the front elevation in 2013. That was to give an impression of the sandstone pillars that had been proposed. The interior of the tea room in 2013. And the side extension. Sorry, it's kind of jumping here. The side extension in 2013. That's the Port Logan Inn as it was in 2011, so that was the original inn. Now, on the question of flooding, I've got a series of images here. This is an image of the rear service yard as it was in 2011. You can just see forward of the stone wall towards the back of the site there is the open stone-lined channel. That's it, as you see it in the left, as it was in 2011. As I say, that has been built over by the park belt extension and has been put into a pipe. So this is the rear service yard as it is today. So as you see, it's been completely covered over. Sorry, I'm having trouble with the... And again, that just shows that the open water course has been covered over as it is today. So this is a couple of views of the culvert, the underground pipe as it is today. That's where it goes under the park belt extension. That is on the southern boundary of the site where it exits the current application site and goes into a culvert southwards before it is diverted into the sea. That's the end of the pipe looking back up, looking north. It's much overgrown now as it compared to what it was when I was last on the site in 2014. So it's harder to see, but that is the pipe. This is as it was in 2012 when I visited the site. You can just see the black pipe underground and then it disappears under the extension that was under construction at that time. Again, that's a better view of the pipe. That's where it's overgrown in the previous ones that I mentioned. So that's where it exits the underground section below the park belt extension, and in the distance you see where it again leaves the site and goes into a culvert there. That's the underground pipe, the end of the underground pipe looking northwards. I have one or two images that were provided by third parties. So this is a view underground. This was provided by an objector to the application. You can see the stone sides of the previous open water course there and the pipe that's been installed under the building. This is an image from pre-2011 showing a flooding event that took place. So that's before any works had commenced. There was a flooding event there, and that was part of the reasoning why we consulted SEPA and flood risk management team. That's an aerial view provided by the applicant. Again, that's just to show you can see the culvert, the open water course, sorry, crossing the site to the rear at that time. Again, this is a view provided by the applicant that again shows the open water course at the rear of the site. And this was a view provided by the applicant. This was as part of his argument with SEPA and ourselves in terms of his justification for putting it underground. He was arguing that it was already underground above and below the site, and therefore why was he being challenged for putting it underground on his site. The difficulty with that is that works north of these works that you see there are permitted development, so we have no control as planning authority. So that being the case, SEPA were never consulted on that. We must deal with what is before us, and what is before us is within the application site, and we have to deal with matters as they are within the application site. Okay, so these are plans submitted with the application as currently proposed. As we go through, I'll show you the previous approval and the previous proposals as a comparison. But as I mentioned earlier, when you're looking at that plan view, as previously approved and previously proposed in 2013, the whole of the rear of the site would have been filled with an extension. As now approved, that very large extension has been removed. The small projection you see from the rear of the main property is the park belt extension that you will have noted in the previous slides. That will have a flat roof on it, and that will be the sum total of the rear extension. And that has been a key consideration for us in terms of the recommendation on this particular application. That's the first and second floor plans. What's now being proposed is 6 letting bedrooms and a 1-bedroom manager's flat, as compared to the previous refused proposal and the approved 2011 one, when they were looking at 15 or 16 bedrooms. So that's much reduced. It's a reduction in 9 bedrooms. Perhaps before I go on, I'll just go back to the previous slide, because I didn't mention. Still my day in terms of now I'm being updated. Yes, I should have mentioned in the right-hand plan view, that shows. Come on, David. The right-hand plan view shows the proposed open watercourse to replace that which was previously there. You can see the line of the previous watercourse running under the corner of the rear extension. That's the line where the current underground culvert is. As now proposed, an open watercourse would be reinstated around the rear of extension across the site. As originally proposed, that was to be completely covered by open mesh decking. SEPA objected to that element of the proposal simply because, well, to go back one stage further, SEPA have an objection in principle to any underground culverting works, and that would be contrary to SPP, simply because anything underground is more likely to block and more difficult to clear, putting it very simply. So when the proposal was to cover the proposed new watercourse completely with mesh decking, they objected to that because, again, if timber or whatever washes down, it's more likely to be trapped there and more difficult to clear. So as amended and subject of a recommended condition, the new open watercourse would only be spanned by one section of decking to a maximum of 3 metres wide. So effectively that would be to give access to the rearward part of the site. So effectively it would be a bridge, but you'd be able to see through it. So that's the first and second floor plans with bedrooms and flat. These are the proposed elevations. Bottom right hand side there, you can see superimposed what was previously approved. So you can see that it is much reduced from what was previously approved and proposed in 2013 to the rear. I'm afraid these don't show up very well, but this was the refused 2013 application. You can see the very large extension to the rear that completely fills the site. Similarly, in that view, that's the lower ground floor plan. This is the first and second floor plans and roof plan. Very large extension to the rear with wall head dormers. One of the reasons for refusal in 2013 was impacts on neighbouring amenity overlooked from these windows. These have now all been removed because that extension has been removed. Those are the elevations as refused in 2013. Again, noting the very large extension to the rear which has been removed. One of the other critical issues at that time was the introduction of a full width balcony excuse me, at first floor level, right along the front elevation, above the tea room extension, whereas in 2011 the balconies were Juliet type balconies there. The full width balcony has been removed in the current proposal, and Juliet type balconies reintroduced, which we consider as a much more appropriate arrangement and less likely to have amenity impacts in terms of privacy and overlook. These are the other side and rear elevations as proposed then and refused. That clearly shows what was proposed in 2013, completely filling the site. This is the 2011 approval, so this is already approved. Now, it's critical in consideration of the current application to understand that the 2011 approval is extant. It has been implemented. So, at the end of the day, any developer could go back to that approval if they so wished. So that approval has been implemented and is therefore secured. So the main difference then, as compared to the 2013 one that was refused, was that the extension to the rear was skewed, whereas the extension to the rear in 2013 was at 90 degrees to the rear elevation. These are the elevations as currently approved, and as I said a moment ago, a developer could revert to that if they so wished. Similarly, that's the 2011 approval. So, to summarise, having considered all matters in relation to the current application, officers' conclusion is that the current proposal is now acceptable, albeit that it could be further improved. It's not perfect. However, what must be considered is the fact that the 2011 approval is in place and could be built. So our conclusion is that the current proposal is now acceptable and indeed represents an improvement over both the 2013 scheme that was refused and indeed the 2011 scheme that is already approved. So because of that, our recommendation to committee is that the application should be approved, subject to conditions.
Thanks very much, Billy, and like many members, I was at Port Logan Bay some time ago viewing this, so please bear in mind we're just dealing with the application before us today. It should be helpful rather than rehash past history. Do any members have any questions for the case officer before we have the objector forward? Andy?
Just a technical one. So, if we were minded to approve today, does that then supersede the 2011 one, or are they still both live? I see you look in your face, Billy. Is it a difficult question, I think?
Billy, answer the question, please.
They could, if you approve this today, developer could change his mind tomorrow and decide to revert to the 2011 permission if he so wished.
You got Jane?
Thank you very much. That was certainly going to be one of my questions. If we didn't have an extant permission at 2011, would we bother with this history? Would we actually simply be saying, sweep the whole thing aside and look at what is on the table now? So we wouldn't be looking...
Yes.
That is a...
It is a material consideration, yes.
Thanks, Jane. Any other members for the case officer? In that case, we have one objector. We have Richard Blakemore. Would you like to come forward, Richard, please? You have 3 minutes, sir, and I'll remind you of 30 seconds to go just to wind up your presentation.
In the planning application report, it states that the applicant intends connection to the public water and sewage system. Later in the report, it states that there are no objections from either SEPA or Scottish Water. This is not correct. SEPA's response clearly identifies a number of operational issues. In item 2.2 of their response, it states SEPA expects for a development of this scale the provision of a detailed wastewater assessment based on the total predicted occupancy of the premises at peak times, which must also include the effluent arising from the catering wash water facilities serving the development. Connection to the foul water sewer would need the permission of Scottish Water, and we would advise the applicant to discuss this matter with South West Water at the earliest possible opportunity. In December, I asked Planning Officer Murray if a letter had been sent to the applicant on this issue. The reply was no. The response letter from Scottish Water, dated July 17th of this year, states that they have no objection to the planning application. However, the application should be aware that this does not confirm that the proposed development can currently be serviced. They advise completing a pre-development inquiry form. Last week, I asked Planning Officer Murray if the applicant had been informed in writing that a pre-development inquiry form should be submitted to Scottish Water. I was informed no. It should be noted that Scottish Water informed planning in 2007 that for application 07/P/1/0117, 7 dwelling houses in Port Logan, that there was insufficient capacity at the Port Logan septic tank for the development. This development producing probably less foul water at peak holiday times than a 7-bed hotel with laundry, restaurant, tea room and bar. In this planning application report, there are no conditions regarding foul water disposal. Why is this? If you vote and approve without a pre-development inquiry form being submitted, and the applicant pumps untreated sewage with a high fat content into the foul and surface water sewer running in front of our homes in Lake Street, it will cause a fat blockage. Our 15 homes will be flooded with rainwater, normally piped from the back of our houses to the combined sewer at the front of the houses. We will have to move out as the sewer is already damaged and unlikely that it will be easily unblocked if choked with fat. Our properties are in a flood risk area and uninsurable against water damage. Given my recent research, these documents and procedures, I am perplexed as to why it appears that the applicant has not been instructed to submit the Scottish Water a pre-development inquiry form for their response. If this had been done in 2014 on submission of the application, you would have all the information you now need. I believe that the Planning Committee would be in breach of the Local Plan, Section IN 9, and Planning Advice Note 79, Water and Drainage, if they voted on this application without having available the Scottish Water response to the applicant's submitted pre-development inquiry. How can you give planning permission without knowing how and if the foul water can be dealt with? We all want the hotel development to go ahead as soon as possible, but only with the proper procedures being followed and acted on.
Can you just wait in your chair, sir, in case there are some questions? It might be helpful if Billy maybe addressed some of the points the gentleman raised before members have questions.
I'll do my best. Mr. Blakemore is quite correct in his references to the SEPA and Scottish Water letter. However, the report is also quite correct in that there are no objections. The points you refer to are not objections as such for planning purposes. These are under operational issues, and these are essentially advisory. Now, what would happen if committee is minded to approve this application today is that a number of appropriate and relevant directives on these points would be attached to the planning decision, advising the applicant or developer to take account of that advice from SEPA and from Scottish Water. It's also fair to say that, you know, Mr. Blakemore has asked me whether I have written to the applicant and told him this. You've got to understand that the applicant and his agent has access to these documents at the same time that the planning authority. So the applicant is already aware of these. In terms of conditions, statutory advice on use, advice on use of conditions and planning permissions is quite clear that planning conditions should not be used to override or reinforce other statutory regulatory regimes. Now that would include, Mr. Blakemore doesn't agree with me, but that is the guidance on planning terms.
Advice 79 does not, that's not right. That's not right.
So that is why we would be attaching directives on these points rather than conditions. There is, however, a condition recommended on surface water, and that would be, again, following advice from SEPA in terms of surface water. and would include the car park across the road that a scheme for disposal of surface water would require to be agreed. In terms of the development impact assessment, again, it's not uncommon for that to be not to be done until after planning permission has been granted. We would not normally request an applicant to carry out a development impact assessment with Scottish Water before the planning application was determined.
Thanks, Billy. Do any members have any questions for Mr. Blackmore? Jane?
Can I just be absolutely clear? Is Mr. Blackmore saying that his property and this property is in a flood risk area?
Yeah, the houses were flooded.
Right. Thank you.
4 years ago, yeah. Yeah, it's not, I have been flooded. My house has been flooded. That's why I'm here. I know exactly what will happen.
Can I just clarify for members on that point as well? It's not a defined flood risk area in terms of the SEPA constraints map. It is an area that may be at risk of flooding, and it's accepted that there has been flooding and it is at risk of flooding. But for planning purposes, it's not a defined flood risk area.
The report actually says that anyway, Jane, and I'm sure you'll have read it. Members, any other questions for Mr. Blackmore? Mr. Blackmore, thank you for your presentation. You can retake your seat. Members were in session. Ian?
Just a quick question on that last couple of points. One point in particular, in regards to who's responsible for the discharge effluent. I take it if it won't be conditioned, there'll be a directive. So therefore, the directive, any misunderstanding or any breach or so on and so forth will be between the applicant, so to speak, or whoever owns the property at that particular moment in time, and Scottish Water, I think, is the authority at this moment in time. Just to get that reassurance, Chairman.
Billy?
Yes, that's correct. And I would also just mention that in terms of Scottish Water's calculations on capacity, their calculations will take into account the fact that there is an existing hotel there. In other words, it's not a complete new 5-bedroom hotel that's being proposed. Their calculations will have accounted for the current proposal, even though it's been closed for a number of years.
Sir, will you please conduct yourself appropriately and no address the committee? We're in session. We have a member of staff addressing the committee, advising of some information that we require. I'd be grateful if you would just leave that be. Thank you. Bill, do you want to continue?
I was just going to, in conclusion, say that what would effectively happen would that if permission is granted and the development is to go ahead, the applicant would have to make an application to Scottish Water for a connection, and they would require him to carry out a development impact assessment, and the planning decision would advise him that he had to do that, and it's then a matter for Scottish Water and the developer.
Thank you. Archie?
I remember this one as well, going to Port Logan and Billy, and there is a lot of enforcement history here. You know, and one of the issues I have with this one is there's a few conditions. Understanding that those conditions will be part of the planning application if it is granted here today, I do have concerns that some of the conditions may not be applied because of the history. Have we got something in place to make sure that those conditions will be applied if we go ahead with it?
Billy?
The same as always applies. We have an enforcement service. If conditions were breached, we would take action as and when appropriate. You know, it's quite clear, and the chairman mentioned this at the outset, that you cannot take into account previous breaches or indeed the characteristics of the previous applicant or developer in your consideration of this application and an assessment of the likelihood of any future breaches. You have to consider this on its merits, although having said that, I'll perhaps contradict myself very slightly and say, as I understand it, the property has recently been put on the market.
Thanks, Billy. Ian?
Thanks, Chairman. Just to move the recommendations, Chairman, as is.
Jane, are you seconding it?
Well, no, I was actually wanting just clarification on the conditions, Chairman.
Well, that's absolutely fine.
Is that right? I just wanted to be absolutely sure. What do we normally put in with respect to lighting? Because if you remember rightly, the last application dealt with lighting. It wanted lighting. They had 8 columns of lighting, and I just want to know what we can do in respect of being sure that the correct lighting scheme will be applied.
David?
2 things there. The previous application... Oh, sorry, David. The previous application actually concluded the lights as part of the proposal. This one doesn't. So the assumption is that they would not be part of any approval. The other point to note is that the lighting would be within the public road, and the Roads Authority would require appropriate lighting if necessary in terms of the existing system of street lighting in Port Logan.
It's really about design and what level of control we have over the issues with respect to design of lighting.
Okay, Andy?
Like Archie, I'm worried about the enforcement history, and I take the point. I take the procedural point where it can't be used. But is there a way, for example, there could be a condition in there that actually said that no work will start until the enforcement notice that's in place has currently been put in? Because you could actually end up with having the stuff that should be knocked down, right, incorporated in the new bill here. So should we not be saying clear the site as a condition and then put the new plan into place for this planning application, as opposed, and that totally separates the 2 plan applications out? Because I'm worried there, but when I see this like a bomb site, you know.
On some occasions, Andy, we build brick onto old rubble and it's existing and it's still there and it's deemed to be appropriate. And I don't think we should be maybe builders. I think we should set conditions that are appropriate for the application and let them go on with it. But Billy or David maybe want to fix that.
I think just to say that what's is now proposed would incorporate all the part-built works that you see there. So the enforcement notice that required reversion only to the 2011 approval would effectively fall because what you see there will be incorporated into the current proposal if it is approved. So therefore there would be no unauthorised elements remaining.
Yeah, Andy?
Okay, I think I've got that, but okay, I'm not happy that an enforcement notice in the past, and that's a different issue altogether, but that's...
I think it's not the first time we've had circumstances, maybe not as extensive as this, but we've had that before and had to be pragmatic about it. I have a proposal from Councillor Carruthers that we approve the application. Is that a unanimous decision, or do we have an alternative proposal? Agreed. Okay, Lucy, can you confirm the decision of the committee, please?
And in relation to item 6, the members have agreed to approve the application subject to conditions.
Thank you, Lucy. We come to item number 7, agenda item number 7, residential and retail mixed-use development at Currie European offices and truck park off the A701, Locharbriggs, Dumfries. The application type is a planning in principle application. The reference number 16/1850/PIP. The recommendation is to approve subject to the successful completion of Section 75 planning obligation within 6 months of the date of the decision, or such other reasonable extended timescale as agreed by the appointed officer, and B, conditions. It's Locker Ward and it's a major application. Should be Chris McTeer again into the lucky day. Robert will take us through this application, and just whenever you're ready, Robert, thank you.
Thank you, Chair. Just going through the slides, first of all. The location plan, it's a site that approximates to 5 hectares. You've got 2 key portions, as you can see from the plan here. There's a portion on the western side of the A701 trunk road. This is as it goes north through Locharbriggs. You can see the other part of the site on the right-hand side, which is used as the truck park at the moment for Currie's European. It's got a a wash facility, an office, porta cabin, so on and so forth within it, and some landscaping. You'll notice directly to the north of that Penman's engineering premises, and to the right-hand side, Catherinefield Farm. On the opposite side, you've got car showrooms at the moment, and you've got Nithcree Trainings building in behind those. The northern buildings are presently office and warehousing facilities, but we'll come on to those. Hemmington, it maybe doesn't come out in this photograph too well, but just directly to the west of the western part of the application site, you've got the cycle path as well, and that forms an embankment. It's an old railway embankment, so there's quite established vegetation on that. But we'll come on to that in the slides. Submissions for permission in principle. So this is an illustrative master plan, so it indicates what could be done. The detail of it is at 1.4 of the report. So application for permission in principle for a mixed-use development. So on the site, on the western section, as you look at it, there we go. So that part of the site, looking at a retail unit of 1,000 square metres with the potential for that to be subdivided into a variety of uses within classes 1, so that's conventional retail, and class 3 is food and drink, and various sui generis uses, so kind of leisure and complementary uses to primarily class 1 and class 3 uses, and a 1,000 square metre warehouse with the potential to facilitate uses within classes 4, so that's business use, and class 6, storage and distribution. On the eastern side section, so across the road, the larger portion of the site, which is used as a lorry park at the moment, they're talking about residential development of approximately 80 units. But obviously that would be subject to further application, as would the opposite side as well. I would emphasise this is illustrative at the moment. What we're looking at is permission in principle. Moving to the slides, these are quite up to date. I was out yesterday taking them. The weather wasn't too good, so I've had to brighten them up a little bit. But the first view is from Martinton Road, and it shows the existing junction with the trunk road, Edinburgh Road, and this is looking towards the car showrooms and Nithcree Training. Second view is just panning around a bit, so more conventionally north, and you can see the existing access to the truck park at the moment on the right hand side. So it curves round from the A701 and disappears there. Moving round a wee bit further, you can see the lane at the moment. The next view shows it a bit more clearly, which goes up to the nursery, B&B and Catherinefield Farm. That shows it a bit more clearly, just going into the distance. So it's surfaced there, but then it becomes a track further along, just into that distance. The entrance to the site at the moment is on the left-hand side, so you've got quite a bit of vehicle traffic using that junction. That's a view from the opposite side, so that's from the western side of the A701, looking back to where I was taking the photos from previously, which is from there. So you've got the application site, the eastern part of the application site on the left-hand side, and the existing access there. And that's a view just showing it more clearly. Panning round, that's looking more towards the north. It's showing the application site frontage, so you've got quite high chain link fencing there with barbed wire on top. Quite a bit of vegetation actually within the site and at the back of it, but we'll come on to that. And you've got quite mature shrubs fronting the site there as well. Moving along, you're getting a view of the opposite part of the site. So at the moment you've got an access point there which serves the car showrooms as well as the offices and the storage buildings. And that shows it in greater detail. You've got the offices there, and you've got storage and distribution buildings there as well. And that gives you an impression of what the frontage is like at the moment. Small portion of land you can see just beyond there is shown in greater detail here. So you've got some activity there before you've got the boundary, some established trees and shrubs to the housing beyond on Edinburgh Road as well. Behind, I was talking about the cycle path earlier and the old railway embankment, you've got quite established vegetation on that there, and you've got established residential development beyond that. This is moving 180 degrees, so this is looking pretty much directly to the east. It's the entrance that serves Penman's Engineering, which is on the left-hand side. You've got the northern boundary of the application site, the eastern portion of it with the palisade fencing there. And that's looking into the site, so you get an idea of the character of it, you can see the vehicles and so on. I would emphasise that this is, where I'm taking the picture from, is not part of the application site, it's simply looking towards it. So that access isn't within the red line. This is going right down to the access track to Catherinefield Farm, and this is, if you like, the southeastern corner of the application site. So you can see that established landscaping there that you saw in earlier pictures, and the fence line, so you've got the agricultural land, Catherinefield Farm here, and the application site on the left-hand side. And you can see the adapted hangar building which serves Penman's in the distance. This is panning round to the right, so you can see the cluster of Catherinefield Farm there. The other thing to note, obviously, is this land is allocated in the local development plan for housing development as a longer-term allocation. So the site is significant in relation to that as affording an opportunity to unlock the constraints that there are on Catherinefield Road. It gives an access opportunity from the A701. Turning to the report, really, the case officer looks at the various issues quite thoroughly. There are some aspects which don't neatly comply with the LDP. However, there are a number of considerable benefits to this proposal, and in most ways it is compliant with the LDP policies. So, in conclusion, we have to recognise that in certain areas it does diverge from the LDP, but in most areas it is compliant. The key benefits, really, the bigger picture issues, the strategic issues and benefits which this would bring, carry a lot of weight. It's also a brownfield site too. It's a conduit, as I say, potentially for further development, unlocking the full potential of a long-term allocated site. And it's a big business and development opportunity in itself, as well as facilitating things elsewhere within the region and keeping, as we understand it, a key business within Dumfries and Galloway. So there are quite a range of positives here, and on that basis the recommendation is to approve this, subject to Section 75 planning application and the conditions listed in the report. And happy to answer questions. Chair.
Thanks, Robert. And bear in mind, members, it's just an in-principle application. We can deal with road layout, design, retail outlets at a more detailed stage if a full application is to come forward. So, any members have any questions for the case officer? David McKee and then Elaine.
I got my east and west mixed up when I was reading the papers at home, but not to worry. Is the intention to convert that existing building on the left? I think that's maybe what he called the west. I notice there's a piece at the back, so it could be extended to the boundary. But is it a case of using that existing building, or is it a case of flattening it and rebuild?
That's just an application in principle, isn't it, Robert?
It is. It's the principle of the land use that's being tested, but I would understand that the intention would be to demolish the existing building and build something new on that part of the site, yeah.
Elaine?
Yeah, thanks. Can I refer to page 112 of 138? It says a retail unit of 100 square metres with the potential to be subdivided into a variety of uses within classes 1, 3 and sui generis. I don't actually know what that means, so maybe you could explain to me what that actually means. I also note on page 120 that the council will support small-scale, maximum 500 metres square gross floor space supermarket convenience store developments to serve neighbouring communities, and I'm assuming that there's not that would be part of a subsequent planning application in terms of actually what was going to be used on that, because obviously we wouldn't want to be giving a green light to something which was not, was larger than the council's preferred options. But anyway, maybe you can tell me what classes 1, 3 and sui generis means.
Robert?
Thanks, Chair. I'm afraid the simple answer is it's planning jargon. There are a number of classes of use of land which are classified, changing in between them is classified as development requiring planning permission. Class 1 is retailing, Class 3 is food and drink. you do have certain types of developments, such as a public house or a petrol filling station, that are described as sui generis, which is Latin terms, which means that they're without a genus, if you like. They can't be categorised, so they're a categorisation in themselves. And it does tend to cover potentially troublesome land uses that don't rub up well against other land uses. So they get categorised themselves. Other things, class 1 will include hairdressers, shops, a range of things. But the sui generis land uses will tend to be types in themselves that you can't move in between. You can't subtly change the use of that unit without a planning application. So it does give an element of control. So apologies for the introduction of that. It's unexplained planning jargon, and we'll try and avoid doing that in future. The point about the policy and the 500 square metres neighbourhood retail facilities, at the moment we're looking at up to 1,000 square metres of retailing, and that doesn't neatly fit with the policy. The policy relates to 500 square metres, and it's geared up to really individual type supermarkets and so on. It may or may not come in future as part of this, but we felt realistically, given that they were talking about subdividing this 1,000 square metres, it was likely, and therefore we felt that policy lent the proposal overall some support, and we should therefore make reference to it. As it stands, 1,000 square metres could be one unit, in which case that policy doesn't really give much support, but we felt it was likely that what we'll see if it's built out and we get detail in due course are a range of smaller units. So we felt that the proposal should get some support from, I think it's ED9, yeah, it should get some support from ED9, so that's why we've included it. But at this stage, we've got no certainty over the size of the exact unit. It's just that the aggregate will be 1,000 square metres.
Thanks, Robert. Ivor?
Chair, it was just a wee bit on the access into Penmans. Now, in the past, that was an access route to the top end of the former aircraft hangar that was in there, onto the Currie site. Are we saying that that will not be allowed to be used as an access? Because I wouldn't want to see a substandard access at that top end. If we're having one access to the site, then try and keep it in a good standard one at the bottom end at the current location.
Robert?
Yeah, Chair, yes, it's exactly as the report. If you look at paragraph 4.19 on page 121, you've got two accesses. So the western portion of the site is proposed to be taken from the existing access to the A701. So that's the one I showed you, which also serves the showrooms in Kirrie. And the eastern section of the site, the bigger part, will be via an upgraded access at Martinton Place. So where I took the first picture, so there'll only be one access point to it. So the one at Penmans beyond the palisade fencing isn't involved as part of this application. It's not within the red line.
Thanks, Ivor. Jane?
The report talks about the application site is currently still in operational use, the transport warehousing hub. We are going to, the proposal is that we permit a change of use of this land in order to permit an existing business to move. Can we condition that as planning authority, or have we got absolutely no control over this whatsoever?
David?
This is an application for the development that's before you. We can't consider the existing applicants and where they may or may not go to. So you've got to look at it solely on the basis of what's before you.
Jane, you want to come back?
Yeah, so in actual fact, what we could do is hand over this land to be changed in use and lose a business that currently is in our administrative area. We have to be completely clear about that. That's what this could be if we gave planning permission in the spaces.
I think that, to be fair to them, have identified land and they have an intention to move, but you're quite right. And it's not for us to judge what other people do. David, do you want to add to that?
No, that's absolutely right. I wouldn't want to mislead members at all on this, that in theory you could approve this and Currie's disappear. That said, we have had discussions with them about various alternative proposals to relocate closer to the A74. So I think there's a clear willingness and intention there, but no, in planning terms, you cannot tie that in.
Archie?
Thanks very much. Just a point of clarity on the planning permission in principle, David, because what we have said is a full planning permission will come forward. But if we grant this today, planning permission in principle, that can be done under conditions, and it wouldn't come back to this committee unless we condition it does come back to this committee like we have done in previous planning permission. But it's just to make members aware that that is the case. I'm not presuming that, I'm quite happy with the report as it is, but I'll come to that in the session.
I think given the interest in the in-principle application, that members would want to see an application before them, and I think it'd probably be a comfort to officers to present it anyway, just to have members see that, and if that's a condition, we can deal with that at the very end. David?
Thank you, Chair. The planning and principle application here shows commercial development on the west and residential development on the east. Because it's only a planning and principle application, is that in any way binding as the division of the site?
No, I think what it does is it allows them to progress an application to a stage where officers can consider it and see whether it's appropriate or no. And at this stage, I don't think we'd be in a position to indicate or direct them to do a specific piece of work. We're just simply saying we're happy to consider this as a change of use, an appropriate use of the land, and if you want to develop it, you bring it forward to us. But David or Robert maybe be more experienced in this particular question than I am.
I'm quite happy to clarify, Chair. We do have a master plan that's been submitted, but that has been clearly labelled as illustrative, so we can't take that to be binding. And yet, yes, that's the way it's been presented at this point in time. But it's why I use the phrase "an illustrative" in the presentation, because we are looking at a permission in principle application. It's for the whole of the application site, so that's what they've indicated at this stage. But there isn't really anything binding when it comes to detail.
Okay, so it could still be that there'd be an opportunity for commercial on the eastern side, because I think it would be strategically a lot better if Dumfries had more land, commercial land near the main roads, and given that this site would open up the site behind, which is probably going to be residential, it would make sense to me that it would be commercial both sides close to the main road.
Thanks, David. Ian?
Thanks, Chairman. Chairman. Happy to go with the recommendations that are here. I think in principle, I'm not overly fussy whether it comes back to us or no, but the thing I don't see within the conditions are probably what I would like to have seen. I think it's more about screening and noise abatement and so on and so forth. When it's adjacent to the commercial side, the Penmans, is there anything there? Have I missed that? Is there something? Maybe I've missed it, but if it wasn't, I'd just like to get the reassurance if we didn't see it coming back, that'll be considered as any future negotiations.
David?
Yes, thanks, Chair. Probably the nearest to that I would suggest is condition 7 on page 124, where we're looking for structural planting. And then it does make mention about to involve details of any earth bunding or acoustic fencing required. So it is covered about that. It was recognised that Penmans did exist in that locality.
Thanks for that, Ian. John Martin.
Thanks, Chair. As I say, realise this is just a principle planning thing. But as I say, while I would have no problem with the eastern side development, the housing side, I think I would have concerns about the western side if we're putting another out of town retail development in there, because as I say, I would hate to see it detrimental to the town centre like we have had at the moment. So as I say, it'll be interesting to see when the full planning does come in, to see what they actually plan on the retail side, because I would hate to see it, as I say, detrimental to Dumfries town centre. It's bad enough for now with the out of town retail developments.
Thanks for that, John. And you're absolutely right. And I'm sure officers are acutely aware of that. Andy Ferguson, then Ivan. Maybe we'll go to the on chain.
Thanks very much, Chair. I'm happy to go along with the officer recommendations here. I'm particularly pleased to see actually that this is happening now rather than relocating and then trying to market or sell or do something with it, like bad examples just a few hundred yards down the road. And I think that's really what I want to put on record here. But I'm happy to go with the recommendations, but I'll wait until you
Well
come
done,
in.
Andy. If you're seconding Ian, that'll be absolutely fine. I think Ian proposed we go with the recommendation. We've got Ivor and then Jane.
Chair, it's just with regard to bringing this back to committee. I would like it to come back to committee more for the sort of the roads issues, the access from Martinton Road, to make sure that we have a good thing in there. And you've also got the fact that if you're putting retail at one side of the road and housing at the other, you've got a major trunk road through the middle of what would be a access to it, and how pedestrians would actually get across that road. I know we're currently looking at getting a pedestrian crossing up at the Old Hall, but you would need some sort of pedestrian access. So things like that, just to make sure that those are in place for the people who are going to be residing there.
Yeah, David will come back on that. We'll get to a condition if there is a proposal to approve this.
Yes, just for clarification, because this is a planning permission principle, the further application would be approval of matters specified by the conditions that you see here. Under the scheme of delegation, it wouldn't automatically come back to this committee, unlike a major application which must go to the committee. But it could well, under the scheme of delegation, have to go anyway, depending if there was representations, objections, or whatever. But what we have done, and Councillor Driver referred to it earlier, is that it's been minuted that a request from the committee that any subsequent applications are referred back to committee. I'm quite happy to do that.
I'll save an argument later on, Ivor. Jane, you, and then we'll get to the recommendation.
Do you know, I'm quite surprised about this. I mean, I think bearing in mind the fuss that we've had over sequential development of retail proposals and the effect on the centre of town. I mean, this report talks about Dumfries being fully occupied practically. Well, I mean, I don't know where on earth anybody's been, but Dumfries is not fully occupied. I mean, it really genuinely isn't. And I would have expected much more of detail from an officer's point of view to explain to me why I should be even considering planning permission in principle. Because remember, members, once you've decided planning permission in principle, that's it. That's the principle. The principle has been decided that you can have retail on that point. As soon as you've decided that, it's done. I must admit, I'm sort of unnerved by this in many ways. I'm unnerved at the removal of ED1. I think ED1A, I think is not fully complied with. And then we go on to the neighbourhood centre, small and rural shops, maximum 500 metres squared, and we're talking about double that without even thinking about it. Yeah, we'll have double. We're not complying with our own policies here. We really aren't. And I am going to propose that we don't agree this. We go through and follow form and get the applicants to do what they should do, which is to market it and do what we require in our own policies. And I propose that we do that. I'll provide you with a wording just in 2 seconds.
You're saying we refuse this application?
Yes, I'm suggesting we refuse it because it doesn't.
Because remember that this is in principle. We then determine what actually is approved at the next stage.
Chairman, I've been there before.
Right, you have a motion to refuse. Do you have a seconder for that motion, David?
I'm not sure.
Could I just address my ignorance here? What is the site at the moment? I know what the site is at the moment. I know Currie's are there, but what's its definition at the moment?
It's a brownfield site, and that's the definition.
And therefore,
sorry to interrupt, but it's storage and distribution use, which is class 6 in the use classes order.
Okay, and what other commercial definitions are available as well? I mean, I guess they're going for light commercial and shop. Maybe they want to build shops, but there are other definitions that one could try to get.
David, this is an application in principle. What is it you're looking to find out?
Well, I'm like Jane, I'm not entirely convinced that houses and shops are the best for this location.
David.
Just to follow up on the comments that Councillor Maitland made, she is actually quite correct in pointing out that it's not just a planning permission principle. when you say it like that, it makes it sound like this is just a pre-application inquiry. This would grant planning permission in principle. The uses proposed would therefore be binding. And all you'll be looking for is the meat on the bones, if you like. It's the detail of what type of houses, what type of units for retail, whatever, are coming forward. Now, as Robert clearly stated at the outset, this does not wholly comply with our policies. We recognise that, and we've tackled that in the report head on. It isn't wholly compliant. We recognise that, but on balance, we reckon that the benefits to the area as a result of various parts of this development would make it such that we can support it. But just to be clear, a planning permission principle does therefore set it in stone that that is what you are allowing on the site. All you're looking at is the detail, and it doesn't wholly comply with policy. We accept that.
You want to come back, David?
Yeah, I would second.
Thank you. In that case, we have a proposal and an amendment.
Just clarify something, because we weren't even in session yet.
Pardon?
We're not even in session yet. So you've got to say we're in session before any motions and proposal.
You're absolutely right. Still questions for the officer. Okay. If there are no further questions for the officer, we're in session. Ian Carruthers and then Jane Maitland.
Thanks, Chairman. I think I would move the recommendations. I think if there's got to be a counter amendment to that, we need to hear the justification why, as we do with any other application.
So you're proposing an application. You have a seconder for that? Andy Ferguson. An alternative proposal, Jane Maitland?
My alternative proposal is that we refuse this because it is premature, in that policy ED1A points 2 and 3 have not been met. And in addition, I don't feel that policy ED9 is fully complied with, in that I don't see a full sequential study to show the impact of retail, of doubling the retail activity on the western part of the site in comparison to our existing policy. I hope that is sufficiently.
And it just occurred to me I didn't give any members time to say anything in session before I asked Ian and Jane to speak. Jeff, you wanted to say something?
Yeah, as I said in the declaration of interest, I've attended a number of public information sessions, and both communities, both sides of that road, Locharbriggs and Heath Hall, are fully supportive of the plans that's put forward here. This is an outline planning application, and they do recognise the need for more housing in that area. Locharbriggs effectively is totally landlocked in terms of further developments, and there's a big demand there. And in terms of what's going to happen with the retail, once again, it's very poorly served, the A701 corridor, in terms of facilities. Basically, between Dumfries and Moffat, there's nothing other than the Tesco's and the filling station. So there's the definite need. And it clearly says in 4.12 that the effect on the town centre would be limited.
Before I ask David to second Jane, is there anybody else that wants to make any observations on this particular agenda item? Archie?
Chair, just to come back, I mean, I'm agreeing with Ian that we should go forward with it, but just that additional condition that any future application comes back to committee.
And David's already undertaken that duty. John?
Yeah, it's just where the housing is going to be positioned. There's a lot of oil facilities there. How are you going to address that?
It would need to be subject to assessment. We recognise it's a brownfield site, so it would need to be considered carefully at that stage when it's brought forward.
David?
Just to say, conditions 14 and 15 on page 125 actually do cover ground contamination.
David James, did you want to second Jane's proposal?
Yes.
Thank you. In that case, we have a motion and an amendment. Lucy, can you take us through the process, please?
You have a motion put forward by Councillor Crothers and seconded by Councillor Ferguson to approve the application as per the report. And we have an amendment forward by Councillor Maitland and seconded by Councillor James to refuse the application.
Members
Ready to
consent?
proceed with the vote?
Ian? Ian?
Just to add, if you don't mind, just that piece that Archie said, I think it's fair enough that the committee sees the detail coming back. It may well or may not be the case if we get local objections, statutory objections, whatever, it would come back automatically, but I think it's important that the committee say that they do want to see it, so let's see it back.
And David's undertaken to bring that to us, yeah.
Noted, thanks.
Okay.
Councillor John Campbell.
Motion.
Oh, it's just wrong.
I wasn't going to argue.
Okay, I've got the wrong sheet, sorry. Councillor Dempster.
Motion.
Okay, Councillor John Campbell.
Motion.
Councillor Blake.
I was absent for most of the presentation, so I'll abstain.
Councillor Doogie Campbell.
Motion.
Councillor Crothers.
Motion.
Councillor Dryborough.
Motion.
Councillor Ferguson.
Motion.
Councillor Gilroy. Councillor Giusti. Councillor Hislop. Councillor James. Councillor Lever.
Motion.
Councillor Maitland.
Amendment.
Councillor Martin.
Amendment.
Councillor McKee.
Motion.
Councillor Murray.
Motion.
Councillor Tate.
Motion.
Councillor Young.
Motion.
And I can confirm that the motion carries by 13 votes to 3. Therefore, the committee have agreed to agree the recommendations and approve the subject. Approve subject to A, the successful completion of Section 75 planning obligation within 6 months of the date of the decision or such other reasonable extended timescale as agreed by the appointed officer, and B, conditions.
And we'll minute that this is going to come back to members when it's submitted in a full capacity. Thank you, members. Come down to agenda item number 8, taking down and rebuilding of a 30-metre boundary wall at Kirk Wynd Cemetery, Langholm. It's a listed building consent, reference number 17/0928/LBC. It's recommended to be approved subject to conditions, and the case officer is Lindsay Little. Lindsay, when you're ready, just take us through your presentation, please.
Sure.
Archie.
I'm just wondering if this is a retrospective application, because this work's already been done. I'm sure Ronnie's going to say the same thing. This work has been done.
It was done on Monday. Lindsay, are you aware of any works being conducted on this site?
At the time of the site visit, the works had not been started, but I understand that they might have been commenced now.
Thanks, Lindsay. I'll ask David's advice on how we deal with this, because if it's been done, it's hardly a planning application.
Well,
it doesn't say that in the papers.
It doesn't say that. I was unaware of any work having taken place, and given who the applicant is, that is particularly disappointing, especially since I would note that there's a number of suspensive conditions. Yeah, what more can I say?
I think members will refer this for further investigation, or defer it for further investigation. I think that might be the best solution, and get an explanation as to why the work's been conducted, if indeed it has been conducted without the appropriate authority from this committee. Ivor?
Chair, would it not be better to actually deal with this, see if there's any conditions being breached that were going to be put in place, and then put enforcement action on?
The difficulty is we cannot serve an enforcement notice on ourselves.
Can we not get somebody else to do it?
It's a technical matter anyway. If we've been made aware by officers or colleagues that the work's been done, we're really no approving an application at all.
Well,
David?
Well, yes, you are. It's still a development that requires listed building consent, even if it is late listed building consent. Obviously, what you cannot do, if it has been done, is the photographic survey to be taken prior to the works taking place, that condition can't be complied with if it hasn't actually been done. We needed mortar samples, so I hope to goodness they have put in proper lime mortar.
Yeah, it has been done. Historic Environment Scotland has been involved. The work has been overseen by that particular organisation, and they were happy with it. When they took the wall down, they thought they were going to have to go underground a little bit where the Kirk Wynd Hill is. They found that the foundations were great, and they did use lime.
Okay, so what do you want, members? We just agree this or deal with it?
Chair, I think it would be appropriate to agree it, but I think there needs to be some understanding for the department to say, you better get a grip of yourselves in the future.
There's also another issue that you can't refuse it or object it if it's been done, which is why it concerns me the way it's been suggested to deal with it today, but I suppose it has to be dealt with. David?
And Chair, the only thing to make a point of is that because the only reason this is before you is because it's a council application. Listed building consent for something of this nature would normally be dealt with under delegated powers, especially seeing as there's no objections to it. So to a large degree, yes, it is a formality, it's coming before you, but I have to say I'm disappointed to hear that, especially given that there were a number of suspensive conditions here, which the applicant section would have been aware of for a week or so. It is disappointing that it has been undertaken at this stage.
Okay, we'll progress with it. Lindsay, can you take us through your images, please? But you'll not need to spend much time on it. Andy?
We can't do this because if it was a member of the public, they wouldn't be allowed to do what we're doing here. So we need to, your displeasure, support David. He's absolutely right. Right.
If it was a member of the public, it would be done under delegated powers. That's the issue.
I think that there are a number of issues to be dealt with, Andy. The problem we've got is it's been done. We're applying an application here before us. It'd be worse if we tell them to take part down again. If the plan application is appropriate and Lindsay's images encourage us to think about that, we'll approve it and then we'll have an investigation into why that came about.
David? What I could suggest, well, if Lindsay can go through a couple of photos quickly, you will see it was a dangerous wall. It had Harris fencing along it, so therefore it was definitely in need of being done. It may have been a justification that it had become even more dangerous and therefore did require. Sorry, I think you'll have to advance them one by one because I was scared it was going to do this because over the recess there was a number of updates, and obviously this is what the computer is trying to do, is update. If you click on the PowerPoint icon at the bottom, it will hopefully kick it back in. Now you should be able to advance it. There we go. What you could do is...
Andy, some images if you want to see them.
When we've gone through the photos, if you are happy with this to approve it, I think we might need to strike one or two of the conditions, but what you could do as a committee was ask for me to write to the applicant section, express your displeasure about the fact it was done in advance of the committee having the opportunity to consider it.
And make sure it doesn't happen again. Lindsay, whenever you're ready.
Thank you, Chair. As explained, this is an application for taking down and rebuilding of 30 metres of cemetery wall at Kirk Wynd Cemetery in Langholm. The block plan shows the location of the section of wall which requires to be rebuilt, and also... Do you want me to do it? Oh, sorry. The block plan shows the portion of wall that needs to be rebuilt, and also a cross section showing the new foundation that's to be laid and the wall to be rebuilt exactly as it is. As you can see, the cemetery lies on a steep hill, and this is a view from the top end of an area known as the Gallop, looking down towards the centre of Langholm. This is the wall looking from the opposite direction up the way from Kirk Wynd. That's a bit of a closer view of the external face of the wall. You can see the public footpath that runs alongside it, and the area which has been fenced off due to the poor condition of the wall. This is a view from the inside of the cemetery. Again, inside of the cemetery, showing the area that's been fenced off. And that's a bit more, a closer view of the poor condition of the wall.
Thank you, Lindsay.
As already explained, the application is put before you because it's Dumfries and Galloway Council as the applicant.
Thank you. Any members have any questions for Lindsay? What, you didn't disturb the residents too much? Archie,
Chair,
and then Ronnie.
I agree with what was said earlier on what should be done. There is of course the issue that if this hadn't been done, the common riding when they went ahead, and you try to stop the common riding in Langholm.
No caring as long as the anchoring goes on. Ronnie.
It says here that the developer shall give 2 weeks' notice in writing of the commencement of the ground disturbance work. Was that adhered to?
David?
Self-evidently, none of these conditions have been complied with. So, no. So unless they have contacted Andrew Nicholson directly and got him to go out. I mean, all I would have to say is that, having just quickly read through them again, these are all suspensive conditions, all requiring certain things to be done. If they've gone and done it, it can only be an approval unconditionally. You've got to strike all these if it's already there. But I would again suggest that one alternative to you might be to request that I write to the relevant section expressing displeasure that that was done in advance and seeking a justification for it. It might be that health and safety grounds, or indeed the common riding, were such that it required it.
I think we'll need to do something because we just can't have the council running roughshod over the planning department. David already said we need to re-amend all of the conditions to reflect the situations, current circumstances and where we are. Ian?
Just more here about, more thinking about it as well. I mean, it makes no odds whatsoever whether we actually agree this today or not. It doesn't have, it'll have no impact whatsoever. I would really like to find out why it's happened. And I suppose the biggest thing for me is, are we treating ourselves the same as we would treat anybody else under these circumstances? And that's, I think, we have to be seen to be doing that. So it's maybe better that we actually defer it, get the background information, and then consider it. And I agree with David, it would have to be unconditionally because it's already done.
And I think we've just done the best of a bad job, Ian, but I'm absolutely determined that we get to the bottom of it, and I think David should bring a response back to us, to the committee, maybe attached to the paper or an independent letter to each of us outlining exactly what the explanation is and what the circumstances were that encouraged the council to carry out work without the proper authority. Joke and then Andy. I'm saying no matter as long as members are aware, and it's whether or not the most appropriate way is it may be in private, and in that way it'll not encourage others to think they can do the same thing. Andy?
Well, that's exactly the point, and it's the point I was trying to make earlier. Right, the public we need to be open and transparent here. Right, we've no complied. Right, for whatever reason, it might be a good reason, it might be a bad reason, right? And the public need to know that we treat ourselves exactly the same way as we would treat them.
However,
I'm sorry, sir, that's the issue. We don't.
Well, I think the other thing is, I mean, it might be was simply a health and safety issue that had to be dealt with. Ivor?
Chair, my concern is whether we agree it or not today makes no difference, because we can't enforce anything from this committee. So, by rights, why do we bother putting planning applications in as a council? Just get on and build it, because we can't actually tell ourselves, sorry, you can't do that.
I think it'll be a statutory requirement. But anyway, what is the decision? We're in session now. We have dealt with all the questions to the case officer. Patsy?
There must have been an order given to do this job of work, and whoever gave that order did it without permission. I would like to see that person here at the next meeting to explain why that was done. I think we need to take a firm view on this. We can't, otherwise it's just a joke, and that's not good enough, and I don't feel happy with that.
You don't know the circumstances. It was maybe health and safety. It was maybe to prevent the common riding.
I'm very sorry that our planning officers
You don't need a person to come and tell you that in person. You just need the explanation written to you, outlining the circumstances. And we'll not speculate today. We may, if we're not happy with the way things have developed, progress the inquiry or the complaint further. But the initial investigation inquiry should simply establish why, when and where and how that took place. That's relatively simple, and we'll know about debate about it surely. Ian.
Chair, that's an operational issue. If there was going to be any discipline or anything like that, that's operational. It's nothing to do with us, that's to do with line managers.
We wouldn't want to deal with that anyway. Ian?
Procedurally, Chairman, I would just move that we defer it until we get the background information and consider it at the next appropriate application meeting. Sorry.
Well, there's a proposal to defer it. Ian?
I'm more than happy to second that.
And tell me, on what basis have we got to defer it because the work's been done? Not being difficult here, but if we defer it, it comes back to another public meeting when other folk are present assessing how we function, how we conduct ourselves.
Chairman, I'm quite happy to justify that in the fact that, I do feel like the public perception would be the right thing for us to do, to take stock and actually see what's actually happened. It could be a simple mistake, it could be the fact that a works order got put out early, or whatever. It could be something really simple. I don't think it's not material, certainly from my point of view, but if we don't be seen at least to be treating ourselves the same way as we would anybody else, whether that's the case or not, in certain circumstances, I think it's the wrong thing to do. For the sake of protecting our own reputation, I think we should defer it. We'll get less publicity around about it. If we do get any, it'll be more positive than just agreeing it today, carte blanching, and getting some kind of report back later.
Proposal for you to defer it, seconded by Ian Blake. Ronnie, and then Ivor.
I think actually, again, I think you hit the nail on the head, Chair, actually. I was on the site once or twice on this, actually, and there was a health and safety problem, really. This affected, I would say, the decision, actually. The health and safety was very prevalent on that. And can I also ask, actually, does this happen very often?
No, really, no.
No.
Ivor?
Chair, I would move that we deal with it today, that we approve, and I would actually keep the conditions in there. I know they can't be implemented, but that's what should have happened, and that's what we should have done. If this had been a member of the public, we could have put that in place, and then we could have served enforcement action, but according to David, we can't serve enforcement action on ourselves. And I think that's where the problem lies, that somebody's went ahead and done this. Whether we defer or actually approve today, refuse, makes no difference. It's been done, and there's no enforcement action we can take. So I would say we approve it with the subject to the conditions in there.
Is there a seconder for Ivor? Elaine? Okay. We have a proposal to defer from Ian Carruthers and Ian Blake, and a proposal to approve to retain the conditions as set out in the report, formed by Ivor and seconded by Elaine. Ian?
Just to qualify, I think, fair enough what Ivor's saying, but I don't think if we can't, when it comes to conditions, if we can't actually adhere to them conditions, I don't think we can actually have them in there. I think we need that qualified.
Well, that's a proposal. If we can do that, David, they can still be there, although whether or not they've been done is a different thing.
Well, if you have a retrospective application, and we obviously, when we wrote this, we didn't realise it was a retrospective application, you would not be attaching conditions which you knew could not be enforced, because that fails the test of Circular 4/1998 about the use of conditions. So I can see why you might want to attach them, but it's a wholly Pyrrhic victory if you actually put them on there, because it doesn't comply, we can't enforce them. But yeah, if you want to attach them, you can, but I would advise you don't.
Ivor, are you happy to amend your motion to simply approve?
Chair, Pyrrhic victory or not, I'll go with what David says, and we'll just move approval.
Elaine, are you happy to support that?
I'll support that, yep.
Okay. Right, so we've got a motion and amendment. You got a counter amendment, Andy?
No, I'm just asking that if there are good, valid reasons why the work had to be carried out before today, then they are included in the minutes so that the public can see the good, valid reasons. I think that's the common sense approach, and then other than that, we'll go with Ivor.
Well, that wasn't what we agreed, though. I don't think we agreed to be circulated privately, the outcome of the inquiry, and I understand that's the best way to deal with this. David, advice on how, or Lucy, how we get this information, because it shouldn't necessarily form part of the minute.
I think it might be sensible, regardless of the outcome of the vote, that an investigation is done, and that it comes back to the chair of the committee and circulated.
I'm certainly quite happy to ask the question of the applicant section and forward on to all members what the response was, and you can decide once you've seen the response any action is appropriate. But certainly Councillor Driver is correct that if you're wanting to do it for disciplinary matters, then that is an operational matter. It isn't something which the committee has any jurisdiction in. If it's purely for information, then I don't see any harm in circulating an email.
So if members are content, we will get a circulated response to the inquiry, and we'll decide afterwards, maybe we discuss that at next meeting, if we get a response in time. Okay, so we'll now go a vote.
A motion put forward by Councillor Crothers and seconded by Councillor Blake to defer the application, and an amendment for Councillor Hislop and seconded by Councillor Murray to approve the application.
Okay.
Councillor Dempster.
Amendment.
Councillor Campbell.
Amendment.
Councillor Blake.
Motion.
Councillor Doogie Campbell.
Amendment.
Councillor Crothers.
Motion.
Councillor Drybrough.
Amendment.
Councillor Ferguson.
Amendment.
Councillor Gilroy. Councillor Giusti. Gone. Councillor Hislop.
Amendment.
Councillor James. Gone. Councillor Lever.
Amendment.
Councillor McKee.
Amendment.
Councillor Murray.
Amendment.
Councillor Tate.
Motion.
Councillor Young.
Amendment.
And I can confirm that the amendment carries by 10 votes to 4 and that members have agreed to approve the application.
Thank you, Lucy. We come to agenda item number 9. This is an appeal decision for information and noting only that the application for a garage information access at plot 2, land adjacent to 3 Cannon Road, Lochfoot, Dumfries was refused by the reporter. Members, any questions on that? No other business. Thank you very much for attendance today, members.